Licensing Commission, if you'll please stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you're not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. We are now going to enter the public comment period so that if there are any members who would like to speak on items on our agenda for today, they may do so. I have one request to speak from Mr. Stephen Knapp.
How's everybody doing today?
Good.
Good.
I see that you also are on the agenda for a complaint. Is that right?
Correct.
Okay. Are you addressing the complaint or something else?
Sort of preliminary statements to the complaint.
Okay, well, we'll take those with your complaint.
Okay, we can do that.
All right.
Thank you.
All right, next item on our agenda, I'd like to welcome our new Commissioner, Charles Sewing. He's just recently been appointed to the Transportation Licensing Commission, so welcome to the commission.
Thank you.
Also, Mr. Rooker, you've notified us that there's a new TLC staff member?
Yes, Mr. Chair. I'd like to introduce Leanne Dickerson, who has joined our staff. She has been with us for a month and a half and doing an outstanding job so far. And so wanted the commission to meet her and look forward to working with her for years to come.
All right, great. Well, welcome. Also, I'd like to recognize that Mr. Billy Fields has retired. He is ridden off into the sunset. We're going to be formally recognizing his contributions and his outstanding tenure as our director for a number of years at our next month's meeting in March. But Mr. Rooker is our interim director as of immediately, so please welcome Mr. Rooker, and we'll, I'm sure, be getting official news on who the director will be in the coming weeks, if not Mr. Rooker himself. All right. Mr. Rooker circulated prior to today's meeting the minutes from our prior meeting. Have the minutes been reviewed by the commission? And is there a motion regarding approval?
We've had an opportunity. I move to approve the minutes from the previous meeting, which would be the December meeting.
I'll second.
All those in favor?
Aye.
Motion passes. We have a couple of public hearings on our agenda today. The first is our annual hearing for consideration of taxi cab certificates of public convenience and necessity. Looks like there are two applicants. Mr. Rooker, any further background?
Yes, Mr. Chair. Tennessee National Cab LLC is requesting 20 additional cabs, vehicle permits for an existing company. Regal Taxi LLC is requesting to operate new taxi cabs with 22 new vehicles. Regal Taxi Cabs representative, Mr. Brian Lewis, contacted us by letter and asked that that could be deferred. No one from that company was available to be here today, but due to family conditions, staff recommendation on these is to defer both until the Connect Downtown study comes out, just like we have, and being consistent with the rest of the public hearing items that we've had, so that we could Connect Downtown out, and then 2 months later, put these things back on the agenda. That would be the recommendation of staff at this point.
Which meeting are you recommending that they be put off to?
It would depend on when the Connect Downtown study comes out. Director?
Thank you very much, Diana Alarcon, Director over the Transportation, Department of Transportation Multimodal Infrastructure, otherwise known as NDOT, to make it easier. We are planning on bringing back before you next month on the final plan and implementation plan of Connect Downtown. So that's in March. So I would say May is when we are recommending it to come back, because that will give us a chance to start implementation.
Well, we know one of the companies already wants to have it deferred. Has there been any input about the other company?
No,
About
sir.
deferral?
I haven't had any communication with that company about deferral or how they would like to proceed.
Just out of curiosity, do we have any sense of sort of where cabs operate in town? I mean, thinking about downtown, airport obviously, but
Yes, ma'am, we do. Typically, it's around the entertainment district. The airport, you're absolutely correct, is mainly where the cabs are actually operating. As part of Connect Downtown, one of the things that we're looking at is actually creating that loading and unloading, that pickup and drop-off area for taxi cabs and also for Uber and Lyft, so it'll make the operations in the downtown or the network system run more smoothly in the downtown. Right now, we do have a problem, I want to say, with taxi cabs sitting in spaces that are not supposed to be with the doors open. We've had many conversations with current taxi cab companies that we need them to stop. So we just want to have a moment where we can actually get everything, kind of implemented, start moving it forward, let everybody know and identify where we're moving them to and what and all of that, and then really take a good look and then bring it back. So that's why we're asking for May. It'll give us a chance to kick that in and then go to the next step.
thank you.
Here, let me move over.
I'm a conscientious observer. They got to share.
Mr. Carr, we are making some room for you over here.
Come on over here, Mr. Clark.
I was so good, thank you.
That's right, sorry.
Well, I'll make a motion that we defer the annual hearing for consideration of taxi cab certificate of public convenience and necessity applications on behalf of Tennessee National Cab LLC and Regal Taxi LLC to the May TLC meeting.
Second.
All those in favor?
Aye.
Aye.
Motion passes.
Thank you.
All right, we have another public hearing on the agenda today for the purpose of reviewing an ordinance to amend Title VI, Chapter 75 of the Metropolitan Code of Laws regarding renewal of pedicab and pedal carriage certificates of public necessity and convenience, and pedicab and pedal carriage vehicle permits, to allow the reduction of the number of such certificates and permits if doing so is consistent with the public convenience and necessity. Mr. Rooker?
Yes, Mr. Chair, I'm going to let legal explain what we're doing here.
Hi, I'm Teresa Costonis with Metro Legal. The 675 is the chapter of the Metro Code that addresses pedal cabs and pedal carriages. And we have one new commissioner, but maybe some of the rest of you will remember that we had an issue come up with regard to the ETVs a few months ago, where there was a concern that maybe they needed to be reduced in number to kind of be more consistent with the Nashville Connect or the Downtown Connect study data. So we had to amend the code to accomplish that. And so we're making the same changes and amendments to the chapter that addresses petty cabs and pedal carriages. Now, this is a council ordinance, so it would have to be adopted by the Metro Council. So this is just to you for your recommendation, since you all are the kind of subject matter experts on this. The text of the bill or draft bill is up on the screen. TD, if you wouldn't mind scrolling down a little bit. Yeah, so you can see the changes that are being made there to 675.030. Is first, it's about the finding that you all make usually in terms of like determining what the public necessity and convenience justifies in terms of number of vehicles. And it allows you or expands your abilities there to be able to determine whether in fact, the public necessity and convenience may lead to a determination that fewer permits than currently exists is kind of what would best serve the public necessity and convenience. And then it amends section 675.060 accordingly, again, allowing you to take that action at the time the annual renewal of such permits comes up. And then the last section that it amends is 675.060, was it? No, oops, 090, yes, thank you. Which it takes renewal out of the types of things that you need to have a hearing, or takes non-renewal out of the types of things that you have to have a hearing for when you're implementing them, just to be consistent with the first two provisions. I'm happy to answer any questions. And the only obligation on you is to make a recommendation to council.
Right. So this just follows the pattern that we have used in other situations.
Only with the ETVs,
With the
but yes.
EVs, yeah.
Can I ask who's going to sponsor the resolution or the ordinance?
We have actually spoken with Councilmember Coopin about being the lead sponsor of it.
So he's fully behind this?
Huh?
Is he fully supportive of it?
He did say he would be our lead sponsor.
Okay.
I have a question, Chair. When we're talking through the Connect Downtown study that we're talking about a reduction of the number of vehicles, these are included in that 90 to something less?
So when the study was done that looked at how vehicles were moving, we could not make a determination of whether it was an ETV or if it was the sightseeing or the pedal carriages either. But we do know that they are moving at less than 15 miles per hour, which is what was established as part of the study. And so they are contributing to the issues that y'all actually established a range for ETVs and sightseeing between 35 and 70. But they do contribute to that issue that we're having of traffic being able to flow efficiently in the downtown core.
Do we know? Wrong one. Do we know how many of them are operating at any given time? Do we have any hard data?
Well, that is one of the things that we are actually going to be doing in April. We've been having meetings with the ETV and sightseeing companies, and it was actually raised by one of the ETV companies, and this is also later on your agenda to... No, well, we do know how many permits are issued, and we do have some ideas, but we don't have some hard data. So we are planning on going out April with drones and actually physically counting how many sightseeing vehicles we have on the road, how many ETVs we have on the road, as well as how many carriages, pedal carriages are on the road as well.
Drones.
A drone, yes, sir.
Keep them out of traffic.
I have received data from, different organizations, but we want to have verified data through us. So we are actually planning on doing that this April.
Ms. Koskonis, can you just kind of summarize what it is that this change is affecting?
So.
Or what is it that we're really recommending, if we recommend it?
So similar to with the ETVs, the way that chapters, both Chapter 677, which dealt with ETVs, and this Chapter 675, which deals with the pedal cabs and pedal carriages, they initially kind of had a presumption of renewal if you weren't going to engage in any, behavior meriting disciplinary action. Given the Downtown Connect study and the range of numbers that data showed where the inflection points were, you all came up with a range of 35 to 70, which is obviously with the ETVs lower than the current number of 90. And so we had wanted to give you all the discretion to be able to look at the overall number of pedal vehicles and pedal carriages, as well as the overall number of ETVs. And when I say pedal vehicles, I don't mean bicycles. I just mean like what are also called rickshaws in state code, like the petty cabs, excuse me. But that number, if it turns out there are more of those currently permitted, then best serves the public necessity and convenience based on the data you are provided. That gives you the opportunity to make a finding that rather than just across the board renewing all of those permits, we may have to renew a lesser number. And I believe Mr. Rooker is working on scheduling some working sessions to talk on the process for, about the process for accomplishing that in the ETV context. And I'm sure that whatever process those work sessions result in would be able to be applied to the petty cabs and pedal carriages as well.
So this proposed ordinance is removing the presumption of renewal and replacing it with a sort of a holistic approach of pedal vehicles as well as the ETVs at assessing what would be an appropriate number.
Correct. And then it allows you to act in accordance with that and provides that other than that annual renewal hearing where you make that finding, that they don't get an additional special hearing on a non-renewal if they are one of the ones that end up being non-renewed. And like how we select which ones will be non-renewed is the subject matter of the work session.
So in all, just to clarify this whole spaghetti of issue that's going on in my head, you guys want us to, anything that's moving downtown, be it a rickshaw, be it the go-karts, all of that, you want all that to be in the number or just?
No, so like the low-speed vehicles, AKA the golf carts, we have not looked at making that change to their ordinance. We haven't looked at making a change to like taxis or other passenger vehicles for hire or breakers. It really is just the slow ones that Ms. Alarcon was referring to.
So you were able to put an ID tag on the ones that were moving faster than 50 miles an hour?
Yes.
Okay.
They were able to actually, yes, they were actually able to study that based on all of the data that we had from collecting and when we were actually looking at the overall traffic and the flow in the downtown area. They are actually able to go in and simulate that and throw in their slow-moving vehicles that were moving at 15 miles per hour. And then when is it that it hits that crunch that it literally brings traffic to a halt or to a jam, that everybody's just not moving. And so that's where that number was. The 35 at the time when we provided and did the presentation, 35 was at peak, 70 was at non-peak. So we know 70 is the number when it starts breaking. 35 is when it's really broken.
But is any of that based on hard data? That's all a simulation, correct?
It's
a
based-
simulation based on estimates.
It is based on data that was collected.
Okay, can we see the data?
Yes.
Is there a process in place or being contemplated that if we do reduce the number of permits after a year, since this is an annual renewal, does an affected company kind of get put in a, cordoned off preference area if the following year or 2 years later we increase the numbers?
So that's an interesting question. I think that would be a great topic for discussion at the work session.
So as I understand it, I mean, essentially, in recommending or not recommending this ordinance to the council, a recommendation for passage could be made because passage of this ordinance would give this body more flexibility.
Yes, it gives you more discretion.
To fulfill our obligation to take a look at public necessity and convenience as we license, in this case, pedicabs and pedal carriages.
Yes, that's exactly correct. So, it's not a mandatory thing, even if this ordinance passes. If you all were to conclude that the number of pedal carriages and pedicabs that are on the streets today is perfectly fine, we would not have to use the opportunity to reduce them in those circumstances, but this gives you the discretion to be able to do that if that's what the data shows you.
I have a concern about the second whereas, though. In the last sentence there, it's as if we've already made a finding that there's a need to reduce the number of pedal carriages and pedal cabs vehicles to increase the pace of traffic in downtown. It's almost as if we're creating a presumption that we have to reduce them with this ordinance, with this proposed ordinance on the whereas there, because we're still waiting for the final information from the downtown study. And I kind of concur with the commissioner at the end of the table there. What we have is theoretical data. The people who were explaining the process to us said that no one has gone out on the street and verified that the data is reliable or verifiable, and the models that were used to create the data have not been subject to peer review at all. So I think there are some questions about, is this data proving out on the street? But I'm concerned about that last sentence there, that we're making a finding that there's already a need to reduce them.
Yeah, well, what I will say, and of course, this language is tweakable, and we expect when it goes to council that they may look at it and may want to make a little change or two as well. Of course, they can at their discretion. And the whereases, like the recitals, are generally not actually a part of the enacted part of the ordinance. So really, it's after the now therefore section 1, section 2. That's really what the ordinance is effectuating. The whereases are just kind of some context for it. So
Could I ask a question? The whereases create legislative intent,
they do.
and so they're not nothing.
So they're not nothing, but they're not actually a part of what's being enacted.
But if you had to defend it in court, those whereases will make a difference because that's legislative intent.
Teresa, for that concern, perhaps maybe could we add due to the potential need in front of that? And would that meet your concerns on that? If the potential need, again, the study that was provided to y'all through KCI is based on facts and not just simulation. What they did is they simulated a 15 mile per hour speed. But the actual number of vehicles is based, that was in the simulation was based on the data that was collected over a year period of the KCI study as part of Connect Downtown. So I just want to clarify that. What they simulated was putting in 15 mile per hour vehicles moving, but the data that was used was based on what was factually collected during the actual one-year study of Connect Downtown at different times, different hours, night, day, week, weekends, and everything, to understand when we started having true impacts to the ability of vehicles to be able to move. So I just want to clarify that a little bit. But Mr. Rogers, I will be glad to get you the data.
Perhaps it could be something in the nature of that renewal of CPN and permits at the April 24th meeting of the Metropolitan Transportation Licensing Commission's consideration of the number of pedal carriages and pedal vehicles to promote traffic in downtown Nashville. But I'd leave it up to other lawyers.
Yeah, that's entirely up to you. You can absolutely suggest amendments to the language of what you recommend.
How many pedicab vehicles are there licensed or permitted presently?
There are currently 26 pedal carriages and 23 pedicabs. So that's a total of 49.
Has there been any input from those companies as to potential language that would allow the commission to lower the number of permits?
No communication that we've received, no, sir.
Certainly, the future working sessions will be open to the public and anyone who can attend who wishes to, see how that.
Does the commission have the power to simply issue that there's going to be a limit as opposed to removing permits to say, okay, well, there's 26 pedal carriage permits, but right now, based on public need and necessity, we've determined that there shouldn't be any more than 20 out at any given time. Therefore, companies, we're going to restrict you. We're not going to take away your permit, but we're going to restrict the numbers to keep this at 20.
I mean, that's not what this bill is written
Right.
to accomplish. Again, it doesn't make you do anything. It just gives you more discretion to make such a finding. It really depends on what you're presented with when the time comes for you to do that. I certainly think we do have more work and discussion to go on in the work sessions as to the process for non-renewal. But please understand if I'm not being clear, at the end of the year, everybody's permit expires. And the question is just, is the renewal of that expiring permit going to be automatic as the default presumption? Or are you all going to have the opportunity to really look at the traffic situation and decide that's what is, in fact, in the best interests of the city?
Well, I think we touched this a little bit before, Commissioner, when we tried to limit or do temporary permits, and that once one is issued, it's issued that they can operate that. I mean, it would be almost impossible to give, say, a pedal tavern company 20 of them and say, okay, only 10 of them on the street from 5 to 9, because they're not the only company. And then we would be out there with tweezers saying, okay, you've got 10, but you've got 20 permits. Oh, these are going back to the shop. These are off duty, but they actually have permits. I would think that would cause a little bit of confusion, or we would actually have to come up with a different type permit, I would assume.
Yeah, I think from an enforcement perspective, it would probably be very challenging.
Is there not any kind of technology where we could track all of these vehicles? I mean, I got air tags on some of my luggage.
So there is technology out there where GPS, and staff has actually had internal conversations about, is that something that we want? And it's something we want to discuss with y'all in the workshop about maybe making that a regulation that we're going to require the ETVs and the sightseeing and even now the pedal carriages and even the pedicabs to carry a GPS so that we are aware where they're at. We currently have that ability with the scooters. So that is something that we do plan on having in a conversation in the workshop.
I'm sorry, when did you say the study would be done?
We're done with the study. And so we are bringing back the final report and implementation plan to y'all next month.
Next month.
Yes, sir.
So this proposed ordinance is just granting the TLC additional discretion to lower the number, put simply. Okay. Meeting, so if there's anyone that would like to speak on this subject, you can come forward. I haven't gotten any formal requests to speak on the matter, but if there's anyone that would like to address the commission, now's the time.
Good afternoon, Chair, members of the Commission. My name is Quan Poole. I'm an attorney at Holland & Knight, 511 Union Street. I represent Sprocket Rocket Tours and Nashville Pedal Tavern. And so this is, I haven't seen this legislation. I attempted to find it on the website and on the council website, and I was unable to do so. So I do think a deferral is warranted. There's a theme that I've heard a few times on this board, and that, you know, we can discuss this in the work session or in the workshop. And so I don't know the rush of adopting this resolution before we have those work sessions, before we have those workshops, in addition to the release of the Downtown Connect study. So I do think a deferral would be appropriate, one, to allow at least my clients the ability to review this draft. In our opinion, I think the commission already has the authority to regulate the number of permits on an annual basis. So I'm just curious as to what the black and white letter law of this ordinance does. The other thing is just that, as Director Rooker mentioned, there are 26 pedal carriages operation right now. And so I don't think those, and certainly most of those 26 vehicles are not on the street at the same time. But I don't think that's, obviously the biggest issue that's causing any congestion in downtown. And we don't know what the Connect study says about that congestion. And so our space, the space of pedal carriages, pretty much has been in operation for over a decade now. The first ordinance went into effect back in 2014. My clients were operating back in 2010 when they were invited to by the Nashville Convention's Visitors Bureau. They wanted to attract talent to downtown and tourism, and they did that. And so it's very difficult for them to be in business and operating for 10 plus years to now be faced with a reduction in the overall number of their permits, particularly considering when just this past year there were over 90 permits issued for another type of use. And so they feel that they're good actors. They feel like they've been operating with very limited complaints, but now they're faced with the potential reduction significantly impacting their business. And so the last thing I'll say, because I know there may be other people that want to speak, to the distinct that there is a reduction, we do feel that there should be some weight or credence given to the operators who have been doing it the right way every year, not had a multitude of complaints. And so the system should certainly be weighted to give them more credence, because you've seen them out in the field, you've seen how they operate, you've seen their business plan versus someone who's going to come new within the last 2 years, and you don't know what their background and how they're going to operate on Nashville streets. Thank you for your considerations, but we would request deferral of this resolution. Thank you.
Thank you.
If I may, Mr. Chair?
Yes.
Mr. Poole, I just emailed it to you.
Okay, thank you.
Is there anyone else who would like to speak on the matter?
It hasn't been introduced yet, has it? I mean, it doesn't have a number.
That's why it's not on, yeah.
It won't be filed until after you make a decision whether to recommend it or not. So no, it's not on file with the council office yet, correct?
At this point in time, we'll close the public hearing.
So just in thinking about this, and there are a lot of attendant issues, obviously, but in my mind, what's before us is whether or not this body wants to recommend that we have the discretion to fulfill our charge of making determinations around public need and necessity when it comes to looking at applications and awarding permits. And from that perspective, I mean, I think having that flexibility so that we can do our job well, I like the idea of not including in the whereas anything that suggests that we're planning to do a reduction, but certainly having that flexibility to do our job the way the ordinance, previous ordinances expected us to, which is looking at that public necessity and convenience makes sense to me. So I would make a motion that we recommend in concept this ordinance.
I'm kind of like an Arnold Palmer here. I'm half and half. In that I agree that it takes away the presumption that just because you have that permit, that you're going to continue to have it because it's been issued and because you didn't run somebody over, that you're just going to have it because it's there. It gives us the flexibility that I think we need as the city grows, as the number of people that live here grow, as downtown grows. And again, as it grows and as it's improved, it also gives us the flexibility to give any permits that we have subsequently taken away during that growth to give them back. Now, on the other side of that, Arnold Palmer, is there are companies that have been in business for a long time and have been good players, as we were told, in that business. And I think in doing that, that has to have some weight to it as far as considering that during that time we invited them into the business, that they made a commitment to the city, and that we should that should have some merit.
And I would say that should have some merit when we're considering those applications and making those decisions. And that's, in my mind, that's different than what we're looking at today, which is just a recommendation about passing an ordinance that gives us some discretion and flexibility.
I agree. I just wanted to put that in the soup for down the road.
I would agree that we already have this flexibility with respect to ETVs and sightseeing vehicles. Why we would not follow that path with this amended language by Commissioner McNally and go forward with this.
Oh, I know it. I don't think there's been a motion. Is this, there was a recommendation.
Second the motion for discussion.
You made a motion?
I'll second the motion and hope we can have some discussion.
Thank you.
Relative to discussion and maybe my edification and other newer commissioners' edification, my recollection of the discussion around ETVs and certainly around the pedal carriages is that you felt, Metro Legal felt, that it was gray. There was a presumption. There was a presumption of a renewal because you have it. But I would think that this authority is, or this commission is specifically here to be able to authorize the number and analyze the number annually. And that as we think about our city over the next 5, 10, 20, 30 years, we absolutely want the ability to be crystal clear that the city has the authority to have the number of permits. And this really is more cleaning up perhaps, what many commissioners previously thought they had, which was an ability to authorize a number of permits.
So both ETVs and pedal cabs and pedal carriages are relatively new businesses. So like as they've come into being, I think maybe the only thought was that they would grow. And this, by the way, this bill does not take away your ability to determine that more permits would be the appropriate number and to grant more and to increase the number of permits when you take that annual look at your number. So I think that's right. I think just like because these businesses are so new, there maybe wasn't enough foresight when things were first written to realize how much they were going to expand. And so maybe we didn't give you quite all the discretion that it would make sense for you to have. But what Commissioner Hayes just said is basically the rationale for this bill, or draft bill, I should say.
And I guess furthermore, the license does expire every year as it currently stands.
What's the timing on all of this? I mean, you heard from Mr. Poole, he was requesting that we defer at the very least so that his clients might have an opportunity to contribute to some of this language and trying to come up with a solution.
So the body of the bill is pretty much identical to the changes that were made to the previously passed ordinance amending 677 on the ETVs. So in that sense, I don't know that I think it's a surprise, but the timing, I think, would be that we would look for the next filing deadline after this meeting, and yeah, I'd have to have 3 readings, that's right. So at least a couple more months, if not 3 months, before it becomes enacted, if that is what the council chooses to do, which is, of course, entirely up to them.
I've got a question. Forgive me for learning on the job here. But as the annual review happens to award or reinstate or renew these licenses, is there currently no consideration on the number of permits? I mean, I've heard you say a couple of times that the presumption of it being automatic, but is there no room at all to determine what that number is? And part 2 is, would more favorable language include, instead of allow to reduce, to say something such as to determine the number, so that that number could go up or down based on, you know, what is it, public convenience and necessity?
Again, you all can absolutely recommend edits to the language that is on the screen, and recommend it to council subject to your recommended edits or amendments to the language on the screen, if that's what you want to do.
When was the last time we approved any more? I can't remember ever approving additional ones. Of course, my memory's fading.
Petty cabs we added.
Okay, that's right, petty cabs.
Pedal
But
cabin's not for a while.
What's the date of the annual renewal?
June. It's June, right?
I thought it was August.
Is it? I thought it was in June. When is it?
They expire in April, the annual meeting's in August.
Okay.
Yeah.
But so during that process, as it stands right now, when it comes to review, is there anything that says, okay, well, we had a certain number last year and we feel like this year it needs to be a different number? Is there not the ability to make that kind of determination as it is now without this language?
Have the ability to either keep it at the same level that it is or increase it, but you don't currently have the ability to reduce it.
So again, I guess that just goes back to my second part of the first question. If language that says to determine the number, if it just says to determine the number.
Yeah, if you wanted to amend
Well-
it to say that, that would be.
Teresa, if I could jump in. It was actually recommended earlier. So if you notice in the whereas, we did change it to say consideration of the numbers of pedal carriage and petty cab vehicles to increase pace of traffic in downtown Nashville. So we did take that in consideration and actually apply that update at that time when y'all were when the conversation started, when Commissioner McNeely started.
You know, and I'm going to go back to what I was talking about I think it ought to just end consideration of the numbers of pedal carriages and pedal vehicles, period. Because when you say to increase the pace of traffic in downtown Nashville, there's only one way to do that, based on what I know, and that is to reduce the number. You can't, it's not, or it's implying that the only thing that that's talking about is reducing the number, because increasing the number is not likely to increase the pace of traffic.
That's right.
I don't have an issue with that.
I'm just trying to keep it neutral.
I
Yeah, okay.
agree.
It should be.
As long as Teresa and Erica do not have a problem, I do not have an issue with that.
Because
No, I have no issue with the,
Okay,
with the edit that was just made. You're welcome. But I think it reads a little funny just grammatically. I think we need a word before. Okay,
Yeah.
okay.
The
just
gra-
saying.
the grammar's not right. Yeah.
Okay.
The grammar is not correct.
Okay. That's all I had.
We'll work on that.
I didn't say I was an English major now.
I want to add a little bit of history here, just from being a little dusty on the board. This number was a lot bigger in the pedal taverns. I mean, in the pedicabs. I remember someone turned in like 14 to 18 of them at one time. This number used to be like up in the 40s. When we started doing ETVs and the increase in the golf carts, this pedicab number was way higher than this already. So I only say that it is evident that it can be reduced without doing it this way, simply by people turning them in and we not reissuing them. Just a little bit of history on how we even got to this number, because this number used to be way higher.
I think that is correct.
Yeah.
Certainly, if people voluntarily surrender their permits, the number can be reduced that way. Like if it turns out it's not a successful business model or whatever. But I think in at least one of the cases I'm remembering, when that number was significantly reduced, I believe the company may have swapped about 20 pedicab permits in exchange for 2 new pedal carriage permits.
I think that was Joyride with Mr. Sizemore, who told us that the pedicabs, or the rickshaws, basically were falling out of favor, and they wanted to go over to the carriages instead. So.
All right, well, I'll add a comment then, and then we'll take a vote. I guess my hesitancy with this language is echoing what Mr. Poole said earlier, which is that the industry hasn't really had a chance to comment on this language that we are now potentially giving our approval to, for the council to enact. And in addition to that, I'm sensitive to any business that is subject to, regulation of, not having kind of a certainty of its operations. And for example, if a pedal carriage company has 5 carriages and they have 5 permits, and then they find out the next year it's only going to be 3, I mean, that's a substantial change to their business. And so I would want, certainly in these work sessions, we're going to have to address that concern. I think that's really important.
If I may, Mr. Chairman, I think the presumption is that the permit is a privilege and not a right. But yes, I absolutely can discuss that and anything else you all want to in the work sessions.
All right, all those in favor of the motion?
Aye.
Any nays? Motion passes.
One abstention.
One abstention.
I'll do a nay.
Let's do a recount. All right. All those in favor, please raise your hand. All those against, please raise your hand. And all those abstaining, please raise your hand. Thank you. Was that enough for passing? Yes. Motion passes. All right, next item on the agenda is under record and towing services. We have been asked to renew new general company's application, a new general company application for Helping Hand Towing. Mr.
Yeah,
Rooker?
Mr. Chair, this actually should have been on the consent agenda. They're not applying to be an emergency or non-consent record, just a.
Could I take us back for one quick second? I just realized that what you recommended and approved was with the changes that you made, right?
Yes.
Yeah.
Okay, I just want to make sure and make clear that that was in the motion.
Yes.
Yeah.
Yes. My motion was actually aside from the back.
All right, Mr. Rooker, back to Helping Hand Towing.
Sorry, I just want to make
Yes.
sure that was clear for the record.
Okay. Helping Hand Towing, this is a mistake. It should have been on the consent agenda. They are not applying for emergency status or non-consent towing, just a general towing application. Their paperwork is in order. Staff would recommend approval.
Is there a motion regarding approval?
Make a motion to approve new general company's application for Helping Hand Towing LLC.
Second.
All those in favor?
Is there discussion? Discussion?
Yes.
Just curious, where do they operate?
I'm not sure of the location, but they're applying to operate all
over the
all over the county.
full-
Yes,
full
sir.
county.
Full county, yes, sir.
Great. Thanks. Just convenience. Okay.
And we only have authority here anyway.
Pardon?
If they were operating in Smyrna.
I wasn't sure if they're regulated to a certain area or countywide, right? There's certain, I guess it's the emergency people have
The
certain
businesses
zones.
that have the emergency tow certification, they get kind of zones divided up around the county in terms of where they tend to handle cases referred to them by police or whatever, accidents. And then also, of course, a tow business can just be the business to tow on a contract basis.
Thank you.
Another vote. Ms. Costomas? We did. Okay. All right. Next item, we've got a number of items under the consent agenda for other passenger vehicles for hire, a number of company applications. Mr. Rooker?
Yes, Mr. Chair. Companies, ABM, Atlas Limo, Black Car Transportation LLC, Chalky, Exclusive Transportation and Logistics, Godfather of Transportation, Happy Ride LLC, I Will Always Care Transportation, J&S Luxury Service LLC, Keith's Car Service LLC, Mr. Jones Driving Service, Nash Rovers LLC, Royal Limousine LLC, Sultan Limousine. All applications are in order, insurance is in place, and staff recommends approval.
Mr. Rooker, for our new commissioner, could you explain what these OPVs are that are applying here?
Yes, sir.
And what they look like on the street?
Most of them are in the category of an Uber Black, which we do regulate. So they're mostly your sedans or your luxury cars that transport folks. So that's most of the OPVHs are the Uber Black cars, vehicles.
What does that stand for?
Other passenger vehicle for hire.
Okay. Thank you.
Yes, sir.
Yeah.
And we have a lot of those out on the streets.
Yes, sir, we do. Actually, we have 427 companies, 700 vehicles that apply under the other passenger vehicle for hire category.
So those that are Uber Black go through a different approval process than your regular standard Uber?
Yes, sir. Well, Uber and Lyft are not regulated through Davidson, through the Transportation Licensing Commission. They're regulated through the state. But Uber Black is regulated by the TLC.
Or is it just that the Uber company requires them to have the TLC license?
That is correct. That is correct.
I make a motion to approve all the OPVH applications en banc all at one time. So that.
Second.
All those in favor?
Aye.
Motion passes for approving the company applications. Next item on the agenda is an OPVH request to modify ownership. Nuri Transportation wants to add a partner, Mohammed Zikri Ziai. Mr. Rooker?
Yes, sir. Anytime that we're modifying the original application, it has to come before this commission, and all they're doing is asking to add a partner, so it would require your approval for that.
Paperwork in order?
Yes, sir. Paperwork is in order.
Was there a background check on Mr. Zai?
Yes, sir. Yeah, there would have been a background check done through the TBI. Yes, sir.
I'll move that we approve the modification of ownership for Nuri Transportation.
Second.
All those in favor?
Aye.
Motion passes. We also have a couple of requests to change addresses for other passenger vehicle for hire companies. K&J to change address to 205 Riverbend Lane in Nashville, and then Shua Limo to change address to 5018 Claude Drive in Smyrna.
Once again, commissioners, just requires your vote, changing that, anything on the original application. They're just asking to change their addresses. Paperwork is in order. Staff recommends approval.
I'll move to approve the change of address for K&J and for Shua Limo.
Second.
All those in favor?
Aye.
Motion passes. Next, we've been asked to recognize a change in the company name and to add a partner for Jeeper Limo Service, to change the name to Fashia Limo Service and add partner Fashia Damtu. Mr. Rooker?
Yes, Chair. Paperwork is in order. Once again, adding a partner, changing the name of the limo service would require your vote. So paperwork is in order. Staff recommends approval.
Well, I've got to ask a question. Why do they want to change their name? Do we know?
No, sir, they don't list that on what they send to us as to the reason.
Are they trying to avoid somebody?
We don't get that far into it, sir. They don't tell us that part.
It looks like Mr. Was it that Fashia said he's putting in some more money, so he wants his name.
Distinct possibility, sir.
All right, I'll approve the change of the company name and adding the partner for Jember Limo Service.
Second.
All those in favor? Aye. Motion passes. Next item on our agenda, we have a disciplinary hearing. We've been asked to review Stephen C. Knapp's complaint against Nashville Booting LLC. Mr. Knapp?
Is there a representative from Nashville Booting LLC present? If you would like to go first.
I'd like to hear from the complainant.
Yeah, this is Mr. Knapp.
I'll take care of that for you, sir.
Yeah.
Yes, sir.
Mr. Knapp, before you present any testimony, I will need to put you under oath. If you want to make an opening, that's fine, but if you want to give testimony, I'm going to have to ask you to give an oath.
Preliminary statement. The complaint sort of speaks for itself. So I'm going to say what I have to say about the complaint. And then again, the complaint speaks for itself and the evidence within it.
Could you tell us what it is? I mean, just give us a summary.
We're happening. It's happening. I just want to make sure everybody has their notes in front of them here. Good afternoon, Commissioners. My name is Stephen Steenapp, and thank you for hearing these comments. I filed this complaint because Nashville Booting lied about its booting permit status and then laughed about it. That is their choice. New documents provided by the MTLC, that is a new booting application dated December 12th, 2023, confirms the complaint's allegation that Nashville Booting has been operating without an active booting permit in force since at least December 1st, 2023. This body has not approved that new application, and it should not. Despite having no apparent approval by this body, the MTLC's current published list of regulated booting companies says Nashville Booting's permit is active. That cannot be true, and citizens deserve to know why. On a broader note, truth and justice are in short supply in America currently. I have showed this body the truth through the complaint with objective evidence that Nashville Booting is operating illegally and with complete disregard to the laws governing booting companies, all while lying to citizens and collecting fees that it has no authority to demand. Now, I am asking this body to do substantial justice, not just for me or my associates, but for the many thousands of Nashvillians forced to pay thousands upon thousands of dollars to a completely lawless and predatory company. A decision to deny Nashville Booting's new application is a decision to uphold truth, justice, and the rule of law. And Nashville Booting's hubris demands that level of justice. Thank you again for hearing these comments and doing substantial justice within our community. That is my statement. If you have questions about the complaint, I'm happy to take your oath and engage with you or defer to Nashville Booting LLC.
All right,
Thank
well,
you.
let me put you under oath because I'm sure we do have some questions, and I would like to hear the presentation of your evidence from you directly.
Yeah.
So please repeat after me. I swear or affirm that the testimony that I'm about to give
I swear and affirm the testimony I am about to give
is the truth, the whole truth, and nothing but the truth.
is the truth, the whole truth, and nothing but the truth.
Thank you. So, Mr. Knapp, if you would please first present the facts that brought us here today with you bringing a complaint against Nashville Booting Company and then also Mr. Fields.
Again. Okay, I don't have the complaint directly in front of me, but the general facts are this. On December 1st, 2023, MTLC's records show the expiration of Nashville Booting's LLC's booting permit. On December 8th, me and my associates were booted. I followed up with Nashville Booting to dispute the validity of it based on MTLC's public records. Over the course of about 12 hours and 50 emails, one of Nashville Booting LLC's representatives basically just lied and said they had a valid 2024 permit. I emailed Mr. Fields and asked, hey, do these guys actually have a permit? He did not provide verification of a permit via email. All he said was that the application for renewal is in review. Now, I'm no attorney, but I don't think a booting application, I don't think a booting permit can be expired, renewed, and under review all at the same time. And if somebody here disagrees with that, I would love to hear your explanation. Those are the general facts. Shortly after that exchange with Mr. Fields, he immediately did an about face and said, oh, no, it's active. And there is no record, public or otherwise, from this body showing that any renewal or hearing took place for that application. Those are the general facts, and I have transmitted the complaint to each one of you individually beyond Mr. Fields' discretion because I have no confidence in him. Are there any questions?
I have a question.
Yes, sir.
Where were you parked that you actually got booted? And was there any signage that said this was private property and that you would be booted?
It was the parking lot across from Schulman's over in East Nashville. I don't have the address in front of me, unfortunately. There is signage, but it does not meet the legal requirements for the company to engage in the practice of booting. As to whether or not I was parked there, it was dark. I manage a rock band. We just went and had a show, going out for some burgers at Schulman's afterwards. Simply, I just didn't see the sign. And that's my fault. I accept that and admit that. But again, if you're not going to put up the legally required signage, if you're not going to take the necessary steps to go through and the approval process that this body has put into place to protect citizens, then what's the point? Any additional questions?
I hear what you've had to say about our rules and regulations. I'm going to further on Commissioner Carr's questioning, and this is just my curiosity more than anything. Do you know who was in charge of, was it revenue for the parking lot? Was it Park Happy or Metropolis? Did you get a ticket for illegal parking?
There was no ticket, just the boot. I did not get that deep into the ownership of the property, but the way that I understand it, based on some initial investigation, is that Nashville Booting LLC is contracted through the operator of the parking lot.
You don't know who the operator is?
I do not know who the operator is.
Mr. Knapp, what is your request of us today?
So the request is that you deny Nashville Booting LLC's new application for a booting permit based on the deception that was offered to me over the course of 50 emails in 12 hours. And it wasn't just me, it was basically 3 of my associates as well. I don't believe that anybody who is entrusted with the power to seize and immobilize people's vehicles should be allowed to do so without the proper permits and without going through the proper process of this body. And then to turn around and basically attempt to deceive people to get away with it, that is not conduct that I find to be honest or that should be rewarded with the opportunity to do additional business and receive permits from this body.
Do you have monetary damages from the paying to have the boot removed?
I do, but they are minimal. They are not worth necessarily filing an individual lawsuit over. Based on the signage requirements that have not been met with Nashville Booting versus the statutes from the state as well as the ordinances, this is most likely a class actionable issue, and I am investigating that. I don't know how long these folks have been operating without meeting the legal requirements, whether it's the permits necessary or the signage necessary to engage in booting, and that is certainly worth looking into. And again, I am not here just for me or my associates. If any of you look at the East Nashville Facebook page, there are constant complaints about booting, specifically Nashville Booting, and just booting in general. It's become out of control. During this hearing, I have heard this commission discuss about how many permits you are able to give, whether you need to give more or whether you have the authority to reduce the permits. I see at least about 10, approximately 10 booting permits that are issued by this body. How many do we need? Is a question I would pose to you as well. But to answer the question, I would ask this body to reject and deny Nashville Booting LLC's new application for a booting permit based on their failure to comply with the laws and regulations of this body.
I have a question for legal, Ms. Costonas. What is the normal process for renewing a booting permit?
Hang on, I was about to pull up the chapter, which is chapter 681 of the Metro Code, but I hadn't quite gotten there yet.
Take your time.
Ask a question in the interim, Mr. Chair?
Yes.
Did you say there were signs up at that lot?
There is a legally required sign according to chapter 6.81. The dimensions of that sign are 18 by 24. Upon personal investigation, that sign does not meet those legal requirements.
Okay. Did you get a chance to go look at this one, Ricky? Well, you were at cruising Englewood.
We have not.
Well, a friend of mine owns the store next door, and he was falsely accused of booting people. He doesn't own the lot.
Yeah, it was unclear whether or not the booting company was the business, the parking lot operator, so that makes sense.
It's the lot that's next to the east side.
I think it's a toy store?
Yeah.
Yeah.
Toy store.
Not the east side tavern.
That might now be Schulin's. It's possible.
You do raise a host of issues. Our Councilman Coopin in the back has spoke with me many, many times about adequate signage for parking lots. I know it's something that he's very passionate about. At least looking at Google, you can see a small no parking sign. I don't see that it says that it's available as a pay lot. It says east side parking only.
I apologize for not being more prepared. I would have printed out pictures of it, but no, I actually went over there and measured it, and it does not meet the 18 by 24 requirements.
Quick question, and maybe Mr. Roper knows this. I mean, I'm trying to understand the relationships. Oh, good, it's on. Thank you. So signage, is signage the responsibility of the owner or parking company? And then they contract with a booting company, and they instruct the booting company to boot?
Booting and towing, in my experience as a parking lot owner, booting and towing companies typically won't come to your property unless the adequate signage is in place.
Okay.
And
But
so
the-
that
but the
raises
signage- But the
a
signage
question.
is the responsibility of the parking company or owner. The signage is not the booting company's responsibility. I'm just, right?
I think that's, I, as the property owner, have had to put signage up that says we will boot or we will tow. We're supposed to have rate signage up on our lots.
I'm sorry.
I might be able to clarify.
Thank you.
So there is, and I'm sorry, I also noted the chapter number wrong. I think I said 680, which is the Wrecker one. It's actually 681 for booting. But at any rate, codes also regulates private lots. You know, there may be some signage obligations on the owners of those lots in that context. I'm really not sure. But here in Chapter 681, there is also a signage requirement that is set out for, as kind of a condition precedent for booting to occur. It doesn't necessarily say who has to install the sign, just that it has to be there.
And the condition precedent is the sticking point for me. These people at Nashville Booting, whether the sign is their responsibility or their employer's responsibility, having that condition precedent not met should foreclose their ability to boot on these properties.
Mr. Roper, did Nashville Booting Company have a permit on December 8th?
No, sir, they did not. They expired on December 1st, and they they reapplied, and their new application was approved on the 12th of December.
I have a question, Mr. Rooker. How does simply reapplying for a new application somehow shed the responsibility to be heard before this commission.
I don't think anybody said that or asserted that at this time.
It was implied.
No, he answered the question that was asked, that's all.
Mr. Rooker, when are renewal applications for a permit supposed to be applied for?
Booting permits are completely different than anything else that we deal with, because booting permits start from the day that the application was asked for. So we don't have an annual hearing for booting companies, and it's the only thing that we don't have an annual hearing for. So if a company is approved, let's just say on July 1, then July 1 the next year it comes due again. So each one of the companies practically has a different renewal date than any other things. The rest of the things we do have a date specific, but booting companies do not.
Mr. Rooker, I object to the term renewal date. No such renewal date exists. There is simply an expiration date.
All right, we're not cross-examining Mr. Rooker here. I'm just simply
There was no
asking a
question
question.
asked.
When is, so you're saying the booting company has the responsibility to apply for another permit before their existing one expires?
That is correct.
That's what I wanted to know. All right.
Mr. Knapp, I have a question.
Yes, sir.
You attached to your complaint an exhibit, which was an email from Mr. Fields, where it says here, Mr. Knapp, the renewal process is underway with the application, insurance, and other documents filed. It is in review, and it's typed by Billy Fields, director.
Correct.
There are no other emails or attached regarding communications with Mr. Fields, is that correct, to your complaint?
That is correct.
All right. And in your complaint, you pointed out that Mr. Fields did communicate with you and informed you that the application was in renewal process, correct?
Again, I object to the term renewal because there is no renewal date. There is no renewal process. There is simply an application, an expiration, and a new application. So while Mr. Fields did offer some sort of reasonable sounding explanation, there is simply no legal or factual basis for that explanation that I am aware of. Thus my question to Mr. Rooker about renewal.
You are familiar with your complaint, correct?
It's not in front of me, but fairly familiar with it.
You drafted it?
I did.
All right. Paragraph 5, page 2 says, also on December 13, 2023, a MTLC Executive Director Billy Fields, parenthetical Fields, verified in writing only that Nashville Booting LLC booting permit renewal application is underway and that such renewal application is in review. That was what the paragraph said, and what I saw as attached here, as I assume supporting your complaint, it said it was the email from Mr. Fields, correct?
That is accurate.
And there's no other information in there regarding other communications with Mr. Fields, correct?
Correct.
All right. So when you made the statement that Mr. Fields, that you said today earlier, that Mr. Fields communicated, or was I mistaken in hearing you say that Mr. Fields supposedly told you that the permit for the booting company was in effect?
I disagree with Mr. Fields' statement that he has the power, or this permittee has the ability to have their application renewed without a public hearing.
The point I'm getting to is that there is no statement in here by Mr. Fields that in December or December 8th of 2023 that this booting company's permit was was active, is there?
Mr. Fields?
And he never said that, did he?
He does not need to say it. I asked for an application, and one was not provided. Or excuse me, I asked for the permit, and one was not provided. Whether he said it or not is irrelevant. What matters is whether the permit was produced.
And he told you that they were in renewal process, not that he was providing you a permit that didn't exist, did he?
Again, what matters is whether or not the permit actually existed on December 8th, which it did not.
It does matter, though, because you brought a claim against Mr. Fields himself, and so that's what we're trying to get at.
Again, the If this body feels that Mr. Fields has acted correctly and reasonably, I'm willing to accept that conclusion. I'm open to the idea of withdrawing the aspects of the complaint against Mr. Fields. I'm open to that. I don't know Mr. Fields personally. Maybe he just had a long day. Maybe he was confused. Maybe he was not sure. I don't know. I did not feel like the information given to me by Mr. Fields was accurate or consistent with the laws and the rules of this commission concerning not only the application process for booting, but also with the facts surrounding Nashville Booting LLC. I reached out to him for help, and there wasn't much help given, and that's all I was asking for.
Ms. Costones, can I ask you a question?
Yes.
Does Mr. Fields have the ability without this body to approve such an application?
He does.
And if an application in
Or he
fact
did, I should say.
if in fact an application or a permit was not in place, does it even come before this board to make a decision on it if there's not one in place?
Commissioner Carr, you're exactly right. So basically in section 681.020 D, capital letter D, the code says application approval and disapproval. Upon disapproval of license application by the MTLC director, the applicant may file an appeal with the MTLC within 30 days of denial and a request an appearance before the MTLC. So it's not even discussed in the context of approval of it going to y'all. The discretion to approve or disapprove lies with the director. If the director denies the application, then the applicant can bring it before the commission, but it doesn't automatically go before the commission.
I object to that interpretation because it does not specifically give the director the authority to unilaterally approve the application. It talks about dismissal, it talks about appeal, but it does not say Mr. Fields has the ability to simply think a permit into existence, especially upon the filing of a new application. That is my sticking point for Mr. Fields. And if I have been incorrect or inaccurate about that, I apologize and I will withdraw the portion of the complaint against him. But I simply disagree with the interpretation from Metro Legal. And I also find that there is no support for that in the actual statute. Simply mentioning the executive director has the power to deny an application does not give him the authority to simply think a new application's approval into existence. And that is my sticking point.
Could I ask another legal question?
Of course.
If the company didn't have approval of their license, do we have authority over them? Because don't we have authority only over license holders?
You have authority over them because they do have a current license, according to Mr. Rooker.
I disagree that
This
their
gentleman
license is
says they were
current.
operating without a license.
On
If they
December
were,
8th.
we don't have authority over them because they're not a licensee.
I mean,
Can't be both.
if they say something, I mean, you guys have authority to take disciplinary action against any permittee, which can be revocation of a permit, suspension of a permit for a period of time. Not sure there's probation.
But even, let's say a company is operating without a license, okay? Do we have authority over them?
If they had ceased to operate at that point in time and never come back before TLC and obtained a new permit, you're correct.
We
Then it
have
would
no
just
authority.
then it would be more just like a violation of the Metro Code in
Right.
terms of operating booting without a permit, and, you know, that could just be enforced in environmental court.
That's
Luckily
civil
for
or
us.
Criminal, right, but not here.
But we have authority, though, that
Because they-
against Nashville Booting today, they are an existing permit holder, and
Yes.
to the extent that they were operating without a permit, we absolutely can suspend them today.
And again, I request a remedy higher than suspension. I request termination. If anybody had the opportunity to read the email exchange that was included in the complaint, Nashville Booting LLC Representative Brian Miller called me a narcissist for attempting to hold them accountable. He said, "I read about you and I want you to do your homework. When you don't get your refund, don't call us. file a complaint, call the police.
Did you ever get your refund?
I got a partial one, but it's not about the money. It's about the hubris and the complete disregard.
I just need some clarification.
Yes, sir.
I read in the emails that you got a $95 refund.
I paid-
Just let me get my question, okay? All right, so what do you mean partial refund?
I paid for one of my associates.
And that, okay. And the associates also were charged a $95 fee.
I was charged the $95 for myself
Yeah.
and for the associate who I paid for.
Okay, and was it the associate's car that was also booted? Or why is the associate paying money?
There were three of us.
Yeah.
3 associates, 3 charges for $95.
Okay.
1, 2, 3. I took care of the 2 of them, one for myself, one for the associate.
All right, so you got $95 back for your vehicle,
Correct.
and the associate did not get his $95 back.
I paid for the associate's $95, and that was not refunded because Nashville Routing felt that because I had received a refund for my vehicle, that our business was concluded.
Okay, so associate number 1 did not get a refund.
Again,
Did the other associate get a refund?
no.
Because we had 3 $95
Correct.
fees, right?
2 of which
How
I'm
much money was
responsible for.
refunded by Nashville Booting to everybody? How much total?
$95 to me.
And nothing to the other 2?
Correct.
Okay.
Is there anything else you'd like to add?
I have no other further comments on this, and the complaint speaks for itself. If anybody has any questions for me additionally, I'm happy to entertain them.
Is there anyone from Nashville Booting here? All right, if you'll please come forward.
I will conclude. Thank you.
Hello, if you'll,
Commissioners, Chair.
please introduce yourself.
Brian Miller with Nashville Bidding.
All right, if you'll please state after me, I swear or affirm that the testimony that I'm about to give
I swear or affirm the testimony I'm about to give
is the truth, the whole truth, and nothing but the truth.
is the truth, the whole truth, and nothing but the truth.
Thank you. Did Nashville Booting have an expired license on December 8th?
Our ownership takes care of the permitting. At the time, I reached out to Director Bill Fields. After this, he said, "We've got your paperwork. We're just going through the steps to get that paper permit out to you."
But did you or did you not have an existing permit on December 8th?
We did not have the physical permit with us now.
What's your role with Nashville Booting?
The operations manager here in Nashville.
When did you find out you didn't have a permit?
During this process with Mr. Knapp, when Mr. Fields told me that we were in process, we didn't have the actual permit, then he called me, I think 3 days later, said, "Hey, your permit's approved." And I've got that approval stuff, I believe, dated on the 12th.
Did you submit your paperwork for getting a new permit on December 12th?
It had been submitted prior to that. I'm not sure the date. Like I said, our ownership handles that out of our corporate office.
I object to that, and I can provide.
Hey, you had your opportunity. You'll have a chance after.
Corporate office in Nashville is the corporate office.
The corporate office is in Atlanta.
Atlanta. Are you guys a national or regional company?
Regional.
Regional.
Have you had any other complaints along this line that you do not have the ability or any other person or persons bring a complaint against you that you shouldn't have booted their car during this time between December 8th and December 12th?
We've not heard from anyone else. We've maintained a license for about 9 years with TLC.
No, I'm just saying in between this period of December 8th and December 12th, did you receive any other complaints from
We've had
from
no
any
other
other
complaints about our
persons?
license now.
Okay.
It'd be December 1st through December.
Oh, December 1st, okay.
Previous license.
Gotcha. So I would say from the 1st to the 12th, did you have any other complaints?
We haven't had none about our licensing.
Who's responsible at Nashville Booting to determine that all permits are up to date and in force?
That's handled by our ownership.
Who is that?
Chip Smeagol?
Chip Spiegel?
Smeagol, S.
And he's in Atlanta?
Yes.
Is he the one who signs the application?
Yes.
And Mr. Rooker, when was that application submitted?
It was approved, something's wrong with my mind. It was submitted, we received the funds to pay for it on the 12th.
Is there a notification that goes out to permit holders that their permit is about to expire?
No, sir, not for booting, no, sir.
Not for booting, so they need to just remember on an annual basis.
Yes, sir.
That it's about to expire. Okay.
Simply because they're all different dates. So
Sure.
All companies have different renew dates.
I'm curious, who initiated though? Can you talk a little bit about the evening and who initiated the request for boot?
For his immobilization?
Yeah.
He was parked at 1290 Porter, a lot owned by CSX Railroad. It is managed by Preferred Parking. It's a company that does paid parking lots here in Nashville. We talked about signage at the entrance of that building. We do have our 18 by 24 sign that is required by TLC. We do provide pictures when we take new properties on. We provide those pictures with those signage to the TLC to show that we have our signage up. The property itself, the payment company does supply their own signs. They've got 4 signs in this very small lot, including their main sign that explains it is a pay and park lot.
And they made a phone call to you guys to dispatch that it was unpaid, or how did that?
No, we audit that lot on hourly or bi-hourly basis, depending on business and timeframes.
Is there a grace period for which booting companies can operate while their license is under review?
No, Commissioner Sewing, there's not. However, with regard to the granting of an application, it is my opinion that the director of the commission does have the authority to grant an application based on the language I read to you before in section 681.020.
Is it safe to assume at this point that it's indisputable that Nashville Booting did not have a permit between December 1st and December 12th?
I've heard the same evidence that you have, but I've not heard anyone make the claim that it was.
Can I ask, do you know how many cars were booted between December 1st and December 12th? You do keep a record of...
We do keep a record. I don't
who you
have
booed
that
and who
with me.
paid you?
Most everything we do is by license plate. So if there is an issue, they'll make.
But
their
you would have
complaint.
received a payment whether you have a license plate or not. You put a boot on, somebody paid you, you keep a record of that.
Yes, we have a online payment system.
So
that
then
have
you
a
would,
record of
you
that.
would have a number of how many people were booted from the
Yes,
1st to the
yes.
12th.
I just don't have.
And
it.
only bring that up to say that if it's found that they shouldn't have been booting from December 1st to December 12th, then everyone booted in between December 1st and December 12th are due a refund.
And I've talked it over with our ownership. We are more than welcome to do a refund to anybody that was immobilized during those timeframes. We would need them to reach out to us or some way have communication with them. As I said, everything we do is through license plate and then.
Well, your license plate would give you all the information for each person.
We have no way to look up license plate information.
How do you, so I guess other parking companies skip trace. So like Metropolis, for example, they do license plate recognition, they capture your license plate. If you don't pay, they send a ticket to the registered address. You probably also know everybody who paid either via credit card or check and could issue a refund via credit card or via check to anybody who had to pay to park during that period.
We're not a parking company, we're the enforcement company. I know a lot of the parking companies, they do have those abilities to scan license plates and find out that information.
But you would have received a check, right? Or does the
Yeah.
check go to the parking company?
Typically, we're receiving credit card. We would have that credit card information.
So you could process a refund and give us evidence of that you've processed a refund.
For anybody that have
Theoretically.
credit cards for, theoretically, yes, we could do that.
Just my curiosity, I was not under the impression that a booting company could audit a lot. I always thought that it had to be a parking management company that would audit, and then that person has to dispatch the boot company to separate. Am I wrong in that?
You just exceeded my knowledge, Mr. Hayes. I'm going to have to look that up.
You're welcome to follow up with me on that at a later period. Yeah, I always thought that, and that's not, I don't know that's necessarily our purview, but when I talk to parking management companies, they've always said that we can't be the ones to boot. We have to call the boot company. And I'm curious what the process is, right? Because and this is separate from the complaint necessarily that we have today. But
A parking company could choose to actually be their own booting company if they wanted to. I think most parking companies actually hire a third-party company to do the booting on their behalf, representing their client for that particular lot if they do not own the lot. But a parking company can actually set up a division within their company that does booting. Most of the time, they actually do go out and hire third-party vendors, though, to handle the booting of the lot.
One less thing to worry about.
They're still responsible.
You're the operations manager, right?
Correct.
All right. Now, tell me, how did it slip through your hands or the company's hands? Surely you looked into this. How did it slip through the company's hands that you were operating while not having a permit in effect?
Over the past several years, we get our paperwork in and the permit just arrives. It doesn't typically arrive.
What happened this time? That's what I'm asking you. Why? Not what's happened in the past, not how it worked in the past. Did you look into why it failed this time?
From what I were told, our ownership got the paperwork together. He sent it out. He did not send the payment with it. And he didn't have everything that was required for it to go through. As soon as he was notified that that information was missing, he corrected that, and we turned all that we were required to turn in.
So would that indicate that the permit application was before this December 12th date? You see, he paid on the 12th, or what I heard was he paid on the 12th. Did they actually make application on or before December 1st?
We'll need to check with staff to see when it actually arrived, when the permitting process of it arrived. I do know that the payment went through on the 12th. I'm not exactly sure when the application was received. They did not come together.
I'm going to play devil's advocate again. I mean, I like doing it. So if we're going to hold the public accountable for signage and the ability to be booted, I would subsequently only think that the reverse would have to be in effect, that we would have to hold the company who is doing the booting accountable for paperwork and knowing that their permit is valid. I mean, there's a weight to it on both sides.
I am curious, the company's been in business for 8 or 9 years in Nashville. Have they been in good standing?
Generally, yes, sir.
Generally, yes.
Yes.
Yeah.
Were you able to go back, Mr. Rooker, and look to see if there were any other lapses by Nashville Booting Company?
No, sir. No other lapses.
No other lapses?
Yes, sir.
Yes.
I just wanted to kind of answer Mr. Hayes's question, and with very great respect, slightly contradict Director Alarcon. So 681-170 does say that it is prohibited for any booting company to be licensed hereunder if that booting service is also engaged in the business of parking lot ownership or owns the property where the booting services are being performed.
And so maybe that's also you're welcome, but maybe that's also a hybrid, right? So Metropolis, as an example, doesn't own many lots, if any. Principals of they manage under a contract. So own is a different word than manage, right? If you were to look at fee simple title, right, they don't have fee simple title to many, if any, parking lots. They manage on behalf of owners. Their principals or their majority equity investors may also own, under different partnerships, parking assets. And the root of my question really was, can...
Booting company cannot be engaged in the business of parking lot ownership. Well, I guess that still implies ownership, or owns the property where the booting services are being performed.
Yeah, and this is, again, it felt a little, it's difficult for me to think that the... Yeah, well, what I was trying to figure out too is...
I believe Metropolis is actually contracted to TriStar enforcement.
They are. Yeah, no, but this is just,
Okay.
I'm wondering, did somebody make a phone call to you, or are you roving around the city looking at parking lots and putting boots on, similar to, like NDOT's contract with LAS parking to enforce? And then at what point in time, does a customer get a ticket versus a boot, right? So if this is a one-off parking company, and the person failed to pay to park, and they didn't see the signage, I hate that it's, and this is just me personally, I hate that it's a boot on a first offense. I'd love to see a ticket, but that's not necessarily my purview. It also, to my fellow commissioners, feels to me as if we've had a company that's been in good standing for 8 years, that they forgot to renew, which happens. They forgot to renew, they forgot to open a letter, something happened. It feels incredibly punitive to me to revoke a permit to operate if that's been the request. I also think, I think Mr. Sewing, maybe you made the point, or somebody else made the point that they operated without a permit. It would seem very reasonable to say everybody should get a refund that got booted during the 12 or 13 days. And maybe there should be a penalty as well for forgetting to renew or just having a lapse.
So that gets to my question, Mr. Hayes and Mr. Rooker. Are there protocols, existing guidelines in place right now for a first infraction, second infraction, anything of that nature?
There are
There's
no...
nothing. So it's just to the discretion.
So it says in the code, if at such hearing the commission finds the licensee or permittee has violated the Metropolitan Code or any provision of Section 681, it may suspend, revoke, or place on probation the license or permit previously issued by it. Of course, in the past, I don't know that we've done probation with booting ever before, but you do have the authority to do it. And we have done it with other types of entities that you regulate. And the concept of probation generally carries with it the idea that it may have conditions on it that need to be fulfilled in order for the probation not to turn into a suspension.
The booting is, for me, just being here, I mean, it's fairly new to us. And what I want to point out is a lot of the booting permits that we have issued have been requested by the property owners, and those booting companies only have the ability to, Marathon Village, only have the ability to boot on that property. I believe the last one we approved was for Marathon Village, and we only gave him approval to boot in Marathon Village on that property. I could be mistaken, but I believe that's what happened.
I mean, I think that may depend. I mean, I think there may be other services that do it more commercially for a variety of customers.
I would caution as we deliberate this to be mindful of any precedent that we might be setting. Just moving forward, if there's occurrences with other companies for something similar, that how we act now, since we don't have anything in place now, is going to set a precedent.
Brian Miller.
Mr. Miller, I don't like the idea of putting the onus on the people who have paid the $95 to reach out to you guys for a refund from December 1st to December 12th. Yeah, I want you to come up with an answer for that. I think at a minimum, you're going to be refunding the funds that you received while you did not have an active permit. I don't know about other sanctions that may be imposed by this commission against Nashville booting, but you've got to come up with some way of refunding these folks.
We can definitely get with our tech department. I can't speak to how that is done right now, but we can look into that and find a way to get that done.
I'll bet if we said we'd suspend you for 60 days, you'd come up with a way, wouldn't you?
I'm not sure what that looks like, but we can find
If there
a way
was
to
a
get
condition
that
of probation to do that, or in lieu of that, have your permit revoked, I bet somebody'd come up with a way, huh?
I can't speak on how to do that, but that is something that we can do.
What would it take to motivate to make sure this happens?
As soon as I can get a hold of our tech department, we can figure out how to process refunds without speaking to those people or getting the card information.
I know Amazon puts it back on my credit card when I for a refund.
I would make a suggestion in that he made a statement earlier that they record every license plate that they actually boot. There is an app that you can put any license plate in, and it will tell you the owner of that license plate. I just showed it to Ms. Alcorn.
Yeah.
So you have the ability to find everybody that you have booted, and I would suggest that we be given a list of everybody that he was booted so that we can verify that that person has been contacted and offered a refund, not just, oh, we had 33 people and we contacted them all and only 15 wanted a refund. That would be, yeah, that would just be too tempting, I would think, to the company. So again, our charge here is public need, necessity, and the safety of the public. And I believe this falls under the safety of the public, and that we are going to protect them against the people that we give permits when they do not act properly.
Do you have a sense of how many, do you have a sense of how many vehicles were booted during that time period of December 1st to 12th?
Typically in a week, we're booting between 150 and 200 vehicles. That's everything between private residential properties, paid parking lots, homeowners associations.
If we gave you 30 days, so to next month's meeting, to come back with the information, would that be enough time?
We wouldn't even need 30 days. That's something within a week's time I could present to TLC.
I did hear lots of oohs and ahs on the number of booths.
Hey, Mr. Hayes, if I could just interrupt.
Sure.
We're having our public hearing, or excuse me, our meeting of the TLC, and it's very important that the public hear us when we speak. So I'm going to very politely ask all of our commissioners to please speak directly into your microphone and only speak one person at a time, so everyone out in TV land, whoever's listening, can hear. Thank you.
No, I heard a couple of oohs and ahs on the number of boots that were you said it was 150 a week or a day?
150 to 200 a week.
A week. As I look at various parking assets downtown that also don't utilize gates, the number of people who either don't see the signage or elect not to pay is in the tens of thousands a day, right? It's a real problem. Adequate signage, people who maybe don't see the signage, don't see the tow warnings, or just elect not to pay. And then the number of people who, hey, you've got a gated lot, and they drive into a gated lot, who decide they're going to drive through the gate or open the gate. We've had, through our parking assets, tens of thousands of dollars of damage to physical gates, to roll down gates that close because somebody doesn't want to pay $5 or $10 or $30 or whatever the charge may be.
In retrospect, less than 10% of the properties that we audit and boot at are the public paid parking lots. Majority of what we do are gated apartment communities, the high-rise gated communities downtown, all the way out to Antioch, outside areas of the downtown area. So less than 10% of what we do is those paid parking lots.
I'm curious, do you have any statistics relative to lies parking in your on-street? How many tickets are being issued, or what % of people pay? Yeah, I mean, is it 50%, 60% pay at the meter?
I would say we are writing approximately about 3,800 citations on a monthly basis. And that's anywhere from overtime, so someone exceeds or stays longer than what they're supposed to be there, or they just do not pay at all. So it's about, I want to say maybe about 3,800 is the average that we are hitting on a monthly basis. And that's made up of over almost 2,500 parking spaces. And remember, we operate 24/7 in the downtown core, and in the midtown, we operate till from 6 a.m. to midnight.
Do you have anything else to add?
No.
Mr. Knapp, if you'll come back forward. I'm going to give you a very brief couple of minutes. Do you have any kind of rebuttal to what you've heard?
I do have a rebuttal. Mr. Hayes, I appreciate your lenience of saying the appropriate punishment maybe isn't termination. I can assure that this board would be appropriate in terminating this permit. Does everybody have a copy of the complaint?
Yes.
All the commissioners need do is look into the exhibit with Mr. Miller's emails. Repeatedly, false statements everywhere. Even here today, Mr. Miller lied to you. He sat and stood right here and lied to every one of your faces. The same way he lied to me over emails. Their sign is not 18 by 24, does not meet the legal requirements. How do I know? I went out there with Channel 4 and we measured the thing. It's on the web right now. I'll send you the news story. And the statute, according to Metro law, is quite clear. If the sign does not meet the legal requirements, you don't need to be booting there. Why would you allow somebody who comes before you and lies to your face to demand money from citizens and seize their property without the authority appropriate from this board? Why is it appropriate to allow them when they sit up here in front of you and lie to your face? And you don't have to believe me. You can go watch the news story, which I'll send to you. Additionally, Mr. Miller claims to have filed a police report against me for theft of services. There was no intent on my part I just didn't see the sign. You're going to let somebody file a false police report for theft of services when they themselves are in the wrong. So, Mr. Hayes, I disagree with you about your leniency. Termination is the appropriate response here. And all you need to do is read Mr. Miller's emails to me over the course of 12 hours and 50 emails. That's what I mean when I say this man laughed about it. He broke the rules. I broke the rules. I didn't mean to. He did. And the evidence of that intent is coming here today before you and speaking falsely right to your face. I have not spoken falsely to you. I have spoken as true as I can to the best of my knowledge. Mr. Miller has also presented no evidence to you that the lack of permit is simply an oversight. When you read his emails to me, you can see that there is not miscommunication or accident. It is impunity. This man feels like he can be held accountable by nobody, especially this body, since he felt okay lying to you to your face. I'm asking this board to do justice, substantial justice, and terminate this permit. Because Mr. Miller and his associates and his owners, they'll just keep on lying to people's faces. And again, no evidence that it was simply a simple oversight. And according to the public record that Metro MTLC delivered, the application was filed December 12th. Not in advance of December 12th, not simply paid on December 12th, filed on December 12th. That was the date of the notary on the application. So again, a second lie from Mr. Miller. Came before you and said the sign met legal requirements. It did not. Said to you, no, we filed it before the 12th. That is false. And again, if you go back to the attitude and the responses displayed by Mr. Miller and Nashville Booting in the emails, you will see that that is a pattern of intent to deceive. The same way he deceived you earlier about the sign and now about the application permit. Corruption often looks like that. It looks like, oopsies, we didn't do a thing. That is why I am asking this board to do the justice necessary and terminate this application. With respect to Mr. Fields, I think that's a legal question of whether or not Mr. Fields has the ability to think a renewal into existence. I do disagree with Metro Legal's determination that he has that ability. And I also want to tell Metro Legal that it is indisputable that there was no permit on December 8th, 2021, no matter what your interpretation is, Ms. Costanis. I apologize if I got your name wrong. The law is affirmative and negative. The authority for Mr. Fields is only what the text of the statute and the ordinance say. And there is no affirmative authority listed in there for him to think a renewal into existence, to make it valid. I've heard a lot of talk today about whether or not we have the authority, whether we do or do not have the authority. That is the affirmative and the negative. And when this section does not affirmatively state that Mr. Fields has the ability to renew a permit upon application, then the only really just thing to do is to assume that he does not. Now, I am not an attorney, but I know a few things. And if anybody disagrees, or if Metro Legal disagrees, you are welcome to correct me. No? Nothing? Just let this show that Metro Legal has no rebuttal.
Mr. Knapp, Metro Legal doesn't have to provide a rebuttal here. We
have the option to.
We have the rule in front
of us. And I have asked them to.
Mr. Knapp,
but they did not.
It's simply, you've established here today through your evidence and also we've heard through the testimony from Nashville Booting that they did not have a permit on the night in question on December 8th. And that's the key thing that you needed to establish today.
I am allowed to ask Metro Legal if they disagree with me, and they do not, because they have not responded.
And I want to make sure I understand.
The commission.
I want to make sure I understand also, withdrawing your complaint against Mr. Fields?
I will withdraw my complaint against Mr. Fields. I will show him some leniency, as Mr. Hayes would like to show leniency to Nashville booting. But because there is some legal question about whether Mr. Fields has the authority, I'm willing to concede that. But I will not concede the fact that Nashville Booting and Brian Miller has come before you today and lied about two material things. The fact that their sign does not meet the legal requirements, and that they submitted the new application when they did not.
All right, thank you.
Thank you.
Before you step away, relative to the sign, the news article, in the news article, you state that it's a 1/4 of an inch too small? It's a 1/4 of an inch?
I didn't make these rules, sir.
I'm just, I want to make sure I've got this clear.
The article
sign-
says what it says.
The sign, yeah, right, in the article, hey, what did you say? If they'll get me for 30 minutes, I'll get them for a 1/4 of an inch. So the sign was a 1/4 of an inch too small.
Again, sir, I did not make these rules.
1/4 of an inch, too small.
I did not make these rules. If
I
Metro,
just, look, we don't have.
again, it's not about the size of the sign, sir. It's about their response.
Correct. We don't have a policy that outlines what happens if a sign is a 1/4 of an inch too small. We don't have a policy that outlines what happens.
Mr. Hayes, I disagree with you. You have an ordinance that says and states what the legal requirements are for the sign to be permitted to be operated.
Metro Codes does.
No, excuse me, it's section 6.81 of the Metro ordinance. If that ordinance is not to be enforced, then a 1/4 inch doesn't matter, you know? But if it is to be enforced, and we are doing rule of law, and we are doing truth and justice, we should stick to the affirmative copy of the ordinance. Does anybody else have a question?
Thank you, Mr. Knapp.
Thank you.
I would like to make an observation, and I appreciate Mr. Knapp, and I think he did the right thing by dismissing the complaint against Mr. Fields, because in the complaint, it simply states that Mr. Fields revealed there was no active booting permit, that he commented that the review was underway, and that was verified by the exhibit attached to the complaint. I'm giving it the presumption of being correct, that it was an email from Mr. Fields saying the renewal process is underway. There was no deception, there was no misleading, and I wanted that I wanted to read that into the record to make it very clear that Mr. Fields did nothing inappropriate or improper in this matter. I leave the rest of it to whatever else we want to consider now.
I would like to make the consideration, even though I understand that the state reaffirmed the 18 to 24 signage here recently. 24 inches, 2 rulers. That's about that big. In a large lot, I would consider that's too small. I do believe there needs to be some consideration by this board on some very distinct rules for booting. I think they are kind of general in where they are now, and with a lot of other things, with the scooters, with the entertainment vehicles, we have made adjustments to them as we've learned some of the thorns on the road, so to speak. But in this case, I think what's before us is, did the company have a license to boot at this time? Did these particular individuals get illegally booted by a company that did not have the authority to boot them? Or they do a refund? I would like to put, in my own opinion, would that merit putting this company out of business? Absolutely not. I have been in business since 2003, and I would need to say I have made some mistakes along the way, and I am gracious that they did not put me out of business because of a mistake. I was given the ability to adjust my business to come within the letter of the law. And in my opinion, a refund is due, not just to this gentleman, but everyone in that period of time that was booted because that company did not have a license. Again, I would like to reiterate, I do not think that is cause to take this company's ability. They've been in business 8 years. I would not think that it would merit taking this company's ability to operate. Having learned how many boots they actually do in a week, going back to Ms. McNally's suggestion that there be some type of prodding to get us this information, and that within 30 to 45 days, if you have not contacted these people, we would like a list of these people and proof of their contact, that if you do not do this, then there would be some action taken afterwards.
Mr. Chair, is it okay if I make a suggestion? So what Commissioner Carr just suggested could be in the form of a condition on probation. So you could put, say, for example, and this is entirely up to you, a company on probation for 30 days on the condition that within that period of time, they track down everyone who was booted during the, December 1 to December 12 period, and refund their money. And, if they get that done by the end of the 30-day period or whatever amount of time is appropriate, then they're, they've never lost their license, they're back in business. But if they don't get that done within the 30-day period, then a suspension could result.
Show proof of that contact, not just say we did. Everybody in my phone calls, I can show you everybody I called today.
Well, I think first we have to take up a motion to determine whether Nashville Booting has, whether the complaint against Nashville Booting and the merits of it have been proven today. Is that correct?
Yes.
Okay.
To you, if that's okay.
Yeah.
It does say another prohibited act listed under 681-170 is for a person or company to engage in the business of providing booting services within the area of the metropolitan government without first obtaining and keeping in force a license from the commission to operate a booting service.
What's that provision?
That is 681-170F.
All right, I make a motion that we find that Nashville Booting LLC violated ordinance 681.170F by operating without an active permit from December 1st through December 12th of 2023.
Second.
Any further discussion? All those in favor?
Aye.
Motion passes.
For discussion about the sanction to be imposed, I agree that I think there ought to be a period of probation and require Nashville Booting to come to us with everyone that was booted and paid a fee, as well as any that may have been refunded. For all I know, there may be some that have already been refunded that we're not aware of right now, but I think they ought to come to us with everyone from December 1st to December 12th of 2023 that was booted, and what their plan is to refund the ones who haven't already been refunded. And I think it ought to be under a condition of probation. And that's just to start the discussion.
Are you saying to require them to make the refunds?
Yeah, I think that we should be requiring them to make the refunds as well, yes. And if they've already started doing that by the time they come back to us, all the better. If not, they need to tell us how they're going to do it so that it can be done in a timely manner.
I mean, they really should stay on probation. If that's the case, they really should stay on probation until everyone has been fully refunded.
I really feel for Mr. Knapp. He has obviously had a tremendous amount of pain and suffering. I can see how difficult this has been for you. I don't know that we would really have an ability to get into any sort of compensation for that or for his time. I certainly respect that he's come here today, but don't think that we can do a thing other than say, look, it sucks, right? Like, it really sucks to get your car booted. It sucks even more to have your car towed and to show up after you've been at the bar for 3 hours and all of a sudden it's not there and you don't know where it is, right? When you've been out at a rock show. I hate that. It's happened to me 30 years ago. Because I was a designated driver and I came back and I missed the sign. I was at MTSU at a concert. I was 21 and I walked out, my car wasn't there. I didn't get it till 3 in the morning because I had to figure out how to get to the place where it had been towed. At least you could see your car and you knew where it was. But it's a horrible feeling when you know, oh God, I made a mistake, I didn't pay. All of that, yeah, I mean, that's horrible. It sucks, right? Like, I can empathize with you that the emails, 50 emails back and forth, that's painful. And I'm sorry you had to go through that. I'm sorry the customer service at the booting company was not great. But there's not a lot we can do. We could revoke a permit. We could say we empathize with you. I think everybody in this room has heard how much pain that you've been in from this experience. And hopefully the booting company learns and they have better customer service that can help you out. Anybody else had a car towed or boot? I mean, it's no fun. Yes.
I've had several at one time.
I'm innocent.
That's because you're a bicycle rider.
And Mr. Knapp, I just want, for me personally, of course I can't speak for the board. I appreciate you bringing this to our attention. This is something that we don't want another citizen to have to address. And it's obviously something that we need to address, and we need to whittle away at the edges of what will make this work properly. Of course, the property owners, they have a right to get paid if people park in their lot, if the signage is correct, and if they are following the letter of the law. But when it is not, you have the right not to pay the penalty for that. And I think it is up to this board, in appreciation of you bringing this before us, to make sure that that doesn't happen to anyone else. So I just want to let you know we appreciate it.
It's not about me, it's about everybody else.
All right, I've got a motion.
Great.
I'd make a motion that we impose a sanction on Nashville Booting Company to be on probation, indefinitely on probation, until the following conditions are met, and I would add that they should be met by our next meeting in March of 2024. Those conditions are: 1, to come to us with a listing of everyone who was booted from December 1st to December 12th of 2023. Identify who has been refunded for the booting and who is left to be refunded. Hopefully you'll have it all done. And also, and a second condition, to come to us with a business plan or a policy about how to handle complaints that are brought to Nashville Booting's attention when people feel like they have been wrongfully booted. I have read all the emails. I'll finish. That's my motion.
I'll second that motion.
All those in favor?
Wait. I want to add a little discussion here. I did read all the emails, and it was, to me, it's my impression, it was tit to tat. There was times when Mr. Miller was saying, I can't do anything more. There was times when Mr. Knapp was pointing out some things that Mr. Miller was not doing that could have been handled better by the representative from Nashville Booting. And that's why I think the second condition, I want to hear what Mr. Miller, your company can come up with for better handling of complaints that are brought to the company by folks who feel like they've been wrongfully booted. Thank you.
Could I ask how many booting companies do we have? I don't.
Seven booting companies
Just
in
seven.
all. Yes, sir.
Okay. Well, they should all be aware of the action today.
We'll make sure that happens, sir.
Is there any reason or concern for privacy or anything with the information that the Nashville Booting Company is providing to the commission?
If there are credit card numbers, that would be protected information under the Public Records Act. I'm not sure. I mean, license plate numbers could be protected as well, driver's license information. I'm not sure what all would be on the forms.
Well, license plates numbers are not privy or protected.
Driver's license numbers are
driver's license number, yes,
under
yes,
the, yes, but I think the,
And they don't have to provide us the credit card numbers. They just need to provide us the numbers and verification that they've complied with the first condition.
All right, I'll go ahead and take a vote. All those in favor of Mr. McNally's motion?
Aye.
Aye.
Any opposed? Any abstentions? Motion passes. All right, I believe that deals with all of the issues with Mr. Knapp's complaint. And it's clear on the record he withdrew the complaint against Mr. Fields. Mr. McNally pointed out what his conclusions regarding the allegations with Mr. Fields regardless. All right, we have other business on the agenda. Mr. Rooker, I'll let you address that.
Yes, Mr. Chair. We're going to have a report on the 2023 SUMD ride summary report, kind of giving you an update on how many rides there were and legislation that may be pending.
SUMD, Shared Urban Mobility Device, encompasses the e-bikes and the scooters. I've got 4 slides, so I'll pause at the end of each. A lot of numbers up here to look at. One thing to note, it was our 3rd consecutive year with scooters of over 1.2 million rides. Introduced e-bikes this past December 18th of 2022. So we had a full year of e-bike rides. You remember 75 e-bikes on the west side of town are out and looking to expand that program.
They can do it now.
Let's expand that program one day. Any questions? Any questions on the first slide? I'll move to the next. These are scooter-specific statistics, total distance ridden, average trip distance, median trip distance, and the average trip duration. And my point of showing these statistics, if you have no questions, I'll go to the next, is the rider behavior from an e-bike trip statistic. Although we don't have nearly as much data, e-bikes tend to be a little further. You stay on the bike a little longer, you go a little further. So something to keep in mind as we look to expand an e-bike fleet in town.
And these are all in a limited geographic area.
Yes, sir.
I mean, you couldn't get on one in 12 South and ride to East Nashville.
That's correct. That's correct. So we do see a longer trip statistic, even though the scooters are currently bound to the entire county. And then going to our last slide here, the past year, the commission voted to expand the first and last mile program to have some scooters staged outside of downtown and midtown. So this about 9% that we're seeing of trip originations outside of central and midtown district is the result of putting scooters out there. So that's an awesome thing to see, that we can attribute 9% of our rides to first and last mile, to trips occurring outside of downtown and midtown. If you have any questions, I'm here to answer those.
And we still don't have any numbers on how many get a scooter at the bus stops, do we?
We don't have specific from the bus stop, but what I can tell you is by contract, that scooters that they can put downtown and midtown, they would put them there. So if there was not additional options for them to deploy scooters outside, they'd probably go where the money is.
Yes, I think they will.
So this 9% of our 1.2 million rides last year, which is about 108,000 rides, occurred not downtown, not midtown, is where they originated. So you can see that effect in the north and the east and the south and Hermitage and in the west.
So I would just like to add to this, we would be bringing to y'all this June, the renewal, a one-year renewal of the scooter contract. However, we are working on an RFP. We have not only the dockless bikes and the scooters, but we also have a current bike share program. And the bike share program actually follows under the SUMD. So it is actually falls in under under your regulation. And currently, right now, we do not have a contract with them. The bike sharing program was originally purchased through grant funding that was received by the health department. It was a program that was put together many, many years ago, and it just kind of has, never really been fully vetted appropriately through the procurement practices of Metro Nashville. So we are putting together a new RFP that we are going to be putting out for all three of them, for scooters, for dockless bikes, and for the bike sharing program. I'm expecting to actually get the draft RFP tomorrow so that I'll have a chance to review it and make sure it's adding it. Couple things is in Connect Downtown, which I'm going to speak more about. We are looking at putting corrals in the downtown area, scooter corrals and bike corrals. And we are going to work with whoever we bring on with this new RFP. That's going to require that the scooters and the bicycles be picked up at either from a docking station or from a corral and be delivered back to it. So we do not have the issue we have today with them being scattered everywhere, all over the sidewalk. That's creating a tripping hazard. And yes, I do have tripping hazards with scooters and bicycles. So we are looking that you can leave it at a bike where we have, we've installed actually a lot of new bike facilities that allow for you to properly secure the bicycle for dockless. Bike sharing would have their own docking, and then also the scooters would have corrals. So that is being pulled together. Our goal is to have that out on the streets next month, the early part of next month, actually have it done and evaluated, and then have a contract we would bring before y'all in April. And then from that contract, it would go on to council for approval so that it can go into effect in June. So just to let you know, we're moving in that direction pretty efficiently and quickly.
As you can guess, I got questions. So today I can get off the bus at Inglewood Kroger and get on a scooter and ride it to my front door, correct?
I believe so. I believe there is some scooters there.
Right. But I can't do that with a bicycle, and you don't want me to do it in the future.
No, I don't have a problem with it. Actually, we are going to have conversations with them because it's really up to the scooter company.
Sure.
They feel like their business is more in line with scooters than bikes from what they've told us. But, technically today they can do it. We, at the time, the council person that was over that district was not interested in doing that. And that's why we actually targeted on the west end. But conversations can happen. But in our conversations that we've had with the scooter companies, it's an investment they have to make to buy the bikes, bring them in town, and actually do them. And with this contract going back out, it's not an investment they're really interested in making.
Yeah, they are.
Okay.
Yeah.
Well, I've been told different.
The contract we approved, 4 years ago, called for a measly 250 bikes. And at the time, I thought, well, that's not many, but we'll get them. Well, we haven't got them yet.
Mm-hmm.
So can you call those companies and tell them to put them out there?
I will.
Okay. And yes, you're right. They don't make much money, if any, off the bikes. So in the future, I will want more scooters because I want more bikes. Some cities require them to put out a certain number of bikes to get the scooters, like Denver. I think it's one bike for 4 scooters or something like that.
Yeah, and we're looking to doing something very similar.
Okay. So in essence, we're looking at, are there going to be 3 RFPs or 2 or?
It's going to be one RFP, and they can offer all 3 services.
Okay. But we could end up with the same companies we have now.
We could, or we could end up with others.
Okay. Well, personally, I don't have a problem with the ones we have now, if we'll, let them expand. Now, one of them is bankrupt.
And one's being bought out.
Oh, really?
Mm-hmm.
Which one?
One's bought the other.
Oh, yeah. Well, they bought another company and then went bankrupt. Bird, yeah, Bird.
They were on the edge of bankruptcy
Before.
Yeah,
I mean,
yeah.
that's been the problem, like nationally,
Mm-hmm.
at least as I've looked at this, the scooter companies, but for a handful of markets, really aren't profitable. They burn billions of dollars.
Oh, well, they burned their venture capital. That's what Bird did. But Lime is, quote, profitable, and I think Lyft is too, as far as I know. And B-Cycle, I assume, B-Cycle's owned by Trek, so I assume Trek is committed to bicycles. Now, they only do dockless, so I assume a company like B-Cycle can apply just for the docked system, correct?
We're looking for a company that can handle all three elements.
Who does that?
There's quite a few companies out there that do.
What cities are doing it with one contractor?
I don't know that answer. I'll have to get that one for
I'm
you.
not sure I don't know of any. I've done a little research. I try to keep up with it. I'm not aware of any city that has just one contractor. Now, places like New York and Chicago, Lyft does their docked system, but I'm not sure they have scooters or dockless bikes. And if they do, it's probably not the same company. Now, I can be corrected. But most cities I've looked at, they have either a docked system, or they have dockless, or they have both.
So it would be our hope, just like we do this with many other contracts, is that perhaps companies will partner and submit an application, a proposal together. So if B-Cycle wants to partner with Uber or Lyft and provide that level of service, we're still going to have a primary contract that we're going to be with, and they would be considered a sub under the contract. And we carry that, we do that with many of the contracts throughout the department.
Yeah, I don't know. I don't think B-Cycle does that. Maybe they'll want to change their model. The problem is, because I want more than one company, obviously, I think the three we've got are just probably not going to be any better ones out there. I mean, Super Pedestrian just closed their doors and sold, 20,000 scooters. The other ones, I guess, are in better shape. So I'm not saying we couldn't do better, but I'm not sure, these two companies are about average for the rest of them, like you're saying. It's not a real healthy industry, that's for sure.
Is there a best-in-class bicycle ride? I know you've got a...
You mean the bicycle?
I'm going to go ahead and step out. I'm going to turn things over to the vice chair.
No, Uber, not Uber, but Bird is an example. I mean, I've read through their bankruptcy filing. I've looked at their business to try to understand if they're going to stay in business. I enjoy riding the Birds. I wear a helmet. I ride on the street.
Sure.
Thank you.
I don't ride on the sidewalk. But I've been nervous about. I guess I've been nervous about their success. I'm one of the people who takes it, and at least in reading about that, I don't see that a core competency of theirs is bicycles. So I'm just curious, from a shared bicycle, are there best-in-class operators that we'd want to attract to Nashville, and how do we do that?
Lime, I think, probably is. From what I've seen in other cities, Lime is more committed to bikes than scooters. But even they will tell you that they don't make much money, if any, off the bicycles. They will do bikes because they want scooters, and they're upfront about that. Lime, I think, is probably, I don't know a lot about the other companies, but I think Lime is probably the best one. Now, Lyft sort of operates in a different space because they do docked systems like in New York, and I think they have Frisco and Portland, and they were in Minneapolis.
That's the same as the rideshare company Lyft, or different Lyft?
No, same Lyft.
Same Lyft.
Same Lyft.
Yeah, they do. They do
profitable for the first time this last.
Well, they do the docking program very much like B-Cycle.
Yeah, it's basically the same. They're in New York with 25,000 bikes, but funded by Citibank.
Well, Citibank is a sponsor, and a lot of the docking. So one of the things is we are requiring that they be self-sufficient. We're not looking to provide them any funding. So that's really important to understand. A lot of cities actually subsidize all of that. They subsidize the docking program. They subsidize even some of the scooters.
Really?
Yes, and we are just not in the position that we are going to subsidize any. So I am expecting that we'll have a little bit less of folks that'll come through. I think we will get folks that have a good financial record and a good business plan, and that this is what they do. And there is quite a few, and I'm hoping we'll get some that'll actually be operating international. There are a lot of international companies that are trying to break into the United States, and I'm hoping a few of them will actually come in considered, and they have a very sophisticated program that works extremely well and integrates with the busing and integrate with the busing system and stuff like that. So there is some moving in a different direction than and yes, they do, and I'm sure that they will actually submit a proposal, and hopefully they'll come in with also a program that will continue to build on the bike sharing program, because that is another means of transportation we want to make sure is provided.
Yeah. Bird and Lime operate internationally, because I've seen them in Europe. And Bird Canada apparently did not declare bankruptcy, and I think they're in Europe too, and presumably. So whoever they've got in Canada is doing a better job than the people they've got here, so maybe they'll switch management. But they are international. But a European company bought Spin and then promptly turned around and sold it to Bird. So I'm not sure that European company would be the one to do business with.
So I'll take a moment. The next item is actually Mr.
Can we come back?
Yes, I'm sorry.
Can you go back through the timeline with me again?
So I'm to receive the draft copy tomorrow. I'm going to be reviewing through it, make sure it's hitting all the ticking points, because one of the things that we want to do is add a penalty that if they do not return it back to so if it's a scooter or a dockless bike and they do not return it to either a corral or to a bike facility station, then they will actually be penalized.
The
user
Okay.
will be penalized, and we are looking to do a revenue share of that penalization so that we can actually have dollars to continue to build out infrastructure. And so I got to run that through a lot of people and stuff, but we're hoping by the end of next week we'll actually have that completely vetted out, that we will then move forward to have procurement get it ready to put on the street. And then we'll have it out on the street. We'll put it out on the street for about 3 weeks, and then hopefully have proposals back, do the evaluation, and then actually bring it back to you in April's meeting. And then once y'all approve it, I then can take it for council for reading.
Can we see it?
Sure.
Okay, because it's public record, right? And I don't want to have to.
Well, in draft form. It's still in draft form. It becomes
So
public.
it's working paper.
It's working paper.
When does it not be a working paper?
When it actually moves to procurement and it's ready to be released.
Or through a Freedom of Information Act request for all emails.
I'm going to put one in.
You don't have to, Mr. Rogers.
But then
I'll
just send it to me.
I didn't say I wouldn't.
Oh, okay, all right, I misunderstood. I'm sorry.
I don't have a problem
Does it-
sharing. I know you're passionate in this area.
Does it, as a scooter rider and maybe someday shared bike rider, how much discussion has occurred with the predominant operators in our city today about their ability to respond within 3 weeks? And I say that it seems like this is new business for them. Their core competency is not bicycles, it's scooters, and maybe I'm mistaken in that assessment. I want to make sure that we've got scooters and ultimately a pathway to bikes. And I'm just curious how the interaction is going, either with our existing providers or other providers, and is 3 weeks an adequate amount of time to get a really thorough response?
It typically is.
They
3 weeks.
do it all over the world.
Yeah, 3
It's
weeks
just-
is actually, most of the times it's 2 weeks, and we're actually going to give them 3 weeks.
And they
Yeah.
are, I've talked to them, they're committed to doing bikes if they get more scooters. And I said, well, that's what I'm for. I don't care about the scooters, I just want the bikes. And it's obvious that's their model.
But it's very problematic. The scooters are a problem. So, we have a max number, and I would actually recommend we stay with that max number because, I'm sorry, Mr. Rogers, they are a safety issue on our public streets
And we need to
and sidewalks.
We need to hold them responsible for dealing with it.
And that's a little bit harder to do. I can't even get them to get out there in a timely manner to pick it up because our contract currently says they have 48 hours, and that isn't efficient for us. Okay. I have a mess on my team is out there moving scooters in the morning now. Downtown Partnership used to do it for us. They stopped doing it because it became a full-time job.
Then we
And
need
so
to,
it is a very big problem that we have to deal with. And so one of the things that we are going to be addressing in the updated RFP is that they're going to have to react in less than 24 hours. I am even thinking of putting it in a 6-hour timeline. And I can tell you they're not going to want to answer to that because that is very costly to them. And they do not want to do that. So that is going to be a problem. And no, sir, I have not had a chance to discuss that with them. But they do know we're moving in that direction because I have been very forthcoming with my thoughts about the level of service that they've been providing and the fact that we have a problem with scooters just trashed all over our sidewalks and our roadway network.
6 hours is generous.
I think it's very generous,
And
but
they are leaving cities because they think they're overregulated.
yes.
Now, I don't know which ones or what they object to, but yeah, you're right.
And
That might be,
other cities like Paris are taking them out.
I know.
Because
yeah,
they leave them all over the place.
well, yeah, Paris is, yeah, but what else did Paris do? Shut down hundreds of miles of streets so I could ride my bicycle. So I'll trade you, okay? No scooters if you'll shut down some streets. One thing is the fact.
You do make my job really, really hard, Mr. Rogers.
Well, hey, you know, the last time I was in Paris, it was different.
Yes,
I want to
that's
go
true.
back. Not this year, though. The companies we have, are they going to get extra points for experience?
Well,
Maybe
there
good or
is.
bad experience?
There is typically a section in there that highlights qualifications. And so that actually, qualification experience, and that gives everyone an opportunity to get points on it. It's not that you get extra points, you get points for qualification and experience, and it can be in other cities. It doesn't necessarily have to be within our city.
Okay. And I'll have an experience on a rental bike in East Nashville tomorrow.
I don't know, sir, because I'll talk to them, but the last time I talked to them, they didn't have bikes, any additional bikes they could put out.
I talked to them. They want to be able to operate in the same footprint as
I will
the
not
scooters.
allow them downtown. So I cannot do that, sir. I
But the
cannot put
scooters are down there and you're
Sir, I
complaining about
do not
scooters.
have the infrastructure and the capacity to handle dockless bikes in the downtown core at this time.
Why are they different than the scooters?
Because they take up a lot more room.
Not a lot more.
Yes, they
That's
do, sir. I have
I'm gonna go out
sidewalks
and
that are
measure.
at 3 feet, 4 feet. They're also heavier. I do not have the capacity in the downtown core to handle additional bicycles.
Okay, so if I want to rent one, I'm sorry to keep everybody here, but if I want to rent one at the Edge Hill Library, which I can do today, I think, and ride it to 5 Points, will I be able to do that?
Where's 5 Points?
In East Nashville.
Oh, I know where, yes, I know where it is. I'm sorry. Great pizza. I'm sorry. I went dead for a moment. No. Well, no, he's asking bikes. So can they pass through?
Because the scooters can,
Your
right?
pedal assist is going to stop, and then you're going to be fined for leaving it outside of the zone. So could you, hypothetically, yes.
Well, wait a minute. I don't want to do it hypothetically.
So
I want to be able to ride it just like a scooter. I don't like the discrimination against bicycles.
Would exclude East Nashville.
Geofencing.
It's going to
Well, no,
exclude
if
East
we,
Nashville?
no, I know, but if we
No.
expanded it, it would, however, the zone downtown would not allow for the bicycle to operate in the downtown core. So we would geofence the downtown core, so that you would have to pedal through downtown, but once you get outside the downtown core, then you would be able to actually use the bike as you did before you got into it. So you would
You
be
get it
pedaling downtown
Without assist?
without assist in the downtown core.
I don't understand that. 'cause
All right,
you-
hold
Yeah,
on one moment. Commissioner Pyle has quietly been holding on to a question
I
down here.
just have a simple question. I've not ever been on a scooter, and I'm not near as passionate as Carrie is about bicycles, for sure. This RFP that you're planning to put out shortly to carry all three of these services, right? Is there an opportunity for there to be less competition for people that provide all three versus, if you're doing just scooters or scooters and dockless versus dock bikes, just in terms of competition, are we increasing or decreasing the amount of competition in any of those services by doing it under one RFP?
I do not know. I really do not know. I do know that other cities have put out RFPs this way that we're replicating, and they've had success with getting competition in their city. So I'm imagining we'll have some similar luck, as they have had. I'm hoping so. And I think it's also an opportunity, so a company like B-Cycle that specializes in docking stations can partner with other companies on putting together a proposal for an RFP. I think it'll give us a little bit more opportunity on the pricing, because right now, I will tell you, when we look at what our price is compared to other cities, we're a little bit high. And so we want to bring that down. But that also, one of the reasons why Nashville is successful is because they are able to generate a revenue here and make a profit, which other cities, they do not. And that's why in some cities, the cities actually subsidize it. But I do get a lot of requests from our elected officials about reducing the cost for a per mile ride on the scooter, the bike, and on the docking stations as well. And so we just want to make sure we can provide that.
And to your question, there are cities that have only dockless, there are cities that only have dock systems, and there's some that got both. I mean, I don't think there is one model.
Yeah.
But I'm not aware of any city that only has one contractor for all of them. So.
All right, in the interest of moving along. The next thing on our other business was, oh gosh, I'm afraid to even ask this, a request for a legal opinion by Commissioner Rogers.
Commissioner Rogers hassled
I have a Connect
Downtown. Yeah, thank you.
Connect Downtown update.
And so there's a couple things that we actually want to ask for consideration of the commission. Connect Downtown, we are going to be back before y'all next month with the report, the final report, as well as the implementation plan to share out with you where we're at and how we're going to proceed forward. So I'm really excited and want to share that with y'all. So with that being said, we have want to make an ask of ETVs and the renewal of the ETVs and sightseeing applications. We've been having meetings with both sightseeing owners as well as ETV owners about their operations as well as what we could do to make the program work better for everybody. And we've had some really good meetings with them. They've been very informal and very open, and I really have appreciated a lot of the business owners coming and having a very frank conversation with us. And so with that, one of the recommendations that came out was the potential of actually putting a drone up and getting an idea of what is actually on the streets. And I agree, I think that's a really great idea. So right now, they are not fully operational because of the weather, so we would want to wait till April to do that. Their renewals and applications are due February 26th, so we want to ask if you would consider extending that until March 26th, and that's when they could be due. That will allow us to continue conversations. We need a couple more conversations to happen between the ETVs and the sightseeing as we continue to work through recommendations that we'll bring and discuss with y'all in your workshop. And so we're asking if you would consider moving back the application due date to March 26th to give us time to have the workshop with y'all and continue those meetings with the businesses. And then the second thing is we would also ask if we can move back the actual renewal date from April, because we want to go out and do the actual drone and capture that data and move that back to May. So those are the two requests, and that also falls in line with Connect Downtown because it'll be allowing us to introduce the implementation plans, what we're doing to move forward. That would be a benefit as well in the ETV world, the sightseeing world, the pedal carriage world, all of that. So we would really like to do that if we could. Oh, I'm sorry.
Are your meetings with both the sightseeing operators as well as the ETV or entertainment vehicle operators, are those open?
Yes. Yes, we've not met with them together. We've done a meeting with the ETV companies, and then we've done a meeting with some sightseeing with the sightseeing companies. And there have been some really good recommendations that they have brought to us that we are actually going to be bringing to y'all in your workshop that I think is really some good solutions. And so we have had to do some more homework based on some recommendations. We need to go back and continue the conversation with both of those groups, and we just need a little bit more time. So that's why we're asking if y'all would consider pushing that out so that we can continue these conversations, because they have been very helpful and they've been, I think, very healthy as well. And I think it'll make the renewal process a lot easier for the commission, which is where we're trying to get.
Do we have the other workshops on the calendar?
That's on the other business coming up shortly.
Oh, you ready to discuss that, Commissioner?
Well, I think we need a motion to move the ET annual hearing to May 16th if the commission is in agreement with that, so.
That doesn't mess us up on any of the other annual hearings and meetings that we need to have, does it?
No, ma'am, it does not.
Okay. If that's the case, then I'll make a motion that we move the annual hearing date for ETs from April to May, and that we use a filing deadline of March 25th for.
A second.
All those in favor say aye.
Aye.
Any opposed? Any abstaining?
Thank you very much.
Anything else on Connect Downtown updates?
No, sir.
Okay.
I'll have it all for you next week, next month.
Next month. All right, Commissioner.
Just one thing on the May 16th date. Maybe you could poll the commission relative to a start time that's a little earlier on the 16th.
There at 8 p.m.
So that we're not going till 8 or 9 or 10 p.m.
On the
Maybe have
16th of April?
Of May.
May, yeah, okay.
Don't know if anybody else has thoughts about that yet, but it'd be lovely not to be here really, really late.
I can certainly send an email out and check to see what everybody's time frame is. And
And I think we have a 5 o'clock drop dead deadline to get out of the building, too.
I believe so. So,
Yeah, so-
let me check availability of the room, and then I
Okay.
will check with you and see what a good time would be.
That's a good point.
May 16th or 15th?
16th. All right, Commissioner Rogers, you're asking for a legal opinion?
I think I harassed Teresa enough. I don't have to ask. Is your promise still good?
Yes.
Okay. There's no big hurry on it, but that's fine.
You want to share with the rest of the commission what this legal opinion might be in 30 minutes or 30 seconds or less?
I want a formal written opinion on whether motorized vehicles are allowed on greenways. And secondary to that, whether electric scooters are allowed on greenways.
Okay.
So just to get it on the record.
Did she give you an answer?
No, but I think I know these. I had a friend of mine look at it, real interesting.
All right, proposed calendar change for, I think we took care of that. The calendar change for the ET annual meeting. Proposed dates for ET workshops, Mr. Rooker.
Yes, sir. We're looking at at least one more date, possibly two more dates now that our deadlines have pushed back. Just needing to look at your calendar, really looking at the last week of February, which would be the 26th through the 29th, or the first full week of March, which would be March 4th through the 8th. A day and time that would work for everyone, making sure we probably get here at 12:30 like normal, and be sure we have the room available up till 5. Just looking for dates, because we need to get all of what we're going to do with the ETVs things in April and May.
First week of March will not work.
Okay. But the 11th through the 15th?
March? I thought you said the last.
Oh, it's spring break, yeah. That won't work either. What about the last weekend of February?
Last week of February?
Last week of February, goes through March 1st. It's 26th through the 1st of March.
I know I'm not available the last week of February and first week of March, so,
And the second week of March is spring break.
okay,
What about next week?
You're not available the last week of February, you said?
correct.
You gotta get that meeting set first with
Okay,
the sightseeing and the TLC.
okay, you're, okay.
Yeah, so maybe the second week,
Second week, spring break.
what does that mean?
It means that no one's here.
No one's here.
Spring break. It means that all the schools are out.
Schools are
Everybody
out
leaves.
and everybody's gone.
Okay.
18th through the 22nd?
I'm available next week.
And no quorum is required for the study session also, so.
What's everybody look like from the March 18th to the 22nd?
You want to try Thursday, what about the 21st, the Thursday? Because y'all are kind of used to Thursdays. Of March, yes, sir.
That's the meeting.
March.
Oh, that is a regular meeting. That won't work.
What happened to the first week of March?
I'm out of pocket, but,
okay.
but
And we
again,
can
we don't
still-
have to have a quorum.
We do not have to have a quorum.
I'm leaving on the 29th, I'll be back on the 5th. Leaving on the 29th of February, I'll be back on the 5th.
What about Thursday, the 7th?
I'm actually back in town that day, so, yeah.
I can do that too.
Thursday, the 7th at 12:30? Does that sound,
11:30, but I'll put it short. Mayor.
okay, March?
The mayor at 11:30 to 1:30?
Oh, is it 1:30?
Yeah.
Can we start at 1:30?
We want to do it at 12, y'all want to start at 12:30?
1:30.
1:30?
That gives you time to get here. There's the mayor's giving a kind of a
Okay.
speech on his transit plan.
I need to, yeah.
That I need to go.
Okay.
When's that?
11:30 to 1:30 at the Grand Hyatt. I don't remember who the group is that.
Pinnacle.
Okay, does the March the 7th at 2?
I can do that.
Okay. And once again, I'll check the availability of the room and what time we would have to be gone from here on that date.
Okay.
I will follow up. I'll send emails out confirming.
Thank you, Mr. Rooker.
Yes, sir.
I don't know why this is under other business, but OPVH driver application review for Adam Mercado Ferrer.
We need to turn the cameras off for the hearing.
Okay. Can we please have the TV cameras and everything turned off?
This will be the last order of
The
business.
meeting is not ended. We are turning off the cameras for reasons that are beyond me.
Yeah.
I'm not sure, are we,
Legal, yeah.
It's
a
to
request.
protect confidence.
I move that we defer the application to the next meeting.
second? All right, all in favor, say aye. Aye. Any opposed? Anything further today?
No, sir.
Well,
Completes our agenda.
Is there a motion to adjourn?
Motion to adjourn.
Second?
Second.
All in favor, scream aye. Aye. All right, wonderful.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.